Well, subject to office time, I want to mention a new content application for enlistment.
No, sorry.
But in the monthly list of August,
Today is not the date for inclusions.
what the matter lead to mention on urgent motion, this matter relate to allocation of LPG cylinder to the Anganwadi. District Magistrate is the authority pass an order for allocation. Whether the BDM, concerned BDM, what are their order issued a new order?
Why will it be here?
Because
This will go before the group 8.
no, this is not the appointment of LPG distributor. This is the allocation of LPG distributor to the Anganwadi Kendra.
The Anganwadi go to the Panchayat bench. Why here? No.
My lord, this is a
No, no.
corporate society matter by clerical.
Society, this bench
My lord, by clerical mistake, they filed the matter in group 9, my lord. And
Clerical, which item?
kindly grant me
Which item?
item number 125, my lord.
Today's list?
Yes, my lord. And my lord, kindly relay the
25, Dr. Rituparna Mukherjee?
yes, my lord. Rituparna Mukherjee.
Released.
Kindly grant me, my lord, kindly grant me leave for the necessary correction in the representative form.
Leave to grant the
also filed petition.
leave to correct the presentation form and the front sheet.
Grateful, my lord.
Group 9,
It will not be group 9. Correction, madam. What is the correction?
I appeared for the state respondents now. When I find the order today, some others' names are recorded in the
Order dated?
Order dated 23rd July, the day before yesterday.
Give.
My lord, kindly praying for the release. Matter is pertaining to police action. Wrongly it is appearing in
Which
119. Today.
119.
190. Saifuddin Ghazi, my lord.
Saifuddin Ghazi released. Leave. Correct the presentation.
May I have your lordships kind leave to mention item number 141. The urgency is that I have supplied hemoglobin meters under the National Health Mission scheme. Last year, my lord, in July, meters as well as strips, they have consumed all of it. When I ask for my payment, almost 4 crore this year, after completing everything, they are saying that all the meters have come up to be inaccurate and everything has to be replaced. If I don't replace it, the remaining 2 years of my contract, it shall be cancelled, my lord. My lord, 4 crores is remaining. I'm not being able to pay my employees. My business has come to a standstill.
Yes. Which item?
141, my lord. This extreme urgency, lordship.
141 next Friday under the heading payment of dues. Serve notice upon all the
I'm
parties.
deeply obliged, my lord.
My lord, may I have my lord's leave, my lord, to mention an urgent matter. The two senior citizens living as a tenant in a property, landlord had some dispute with the bank. The bank has given a false undertaking saying that the property is vacant and has taken over possession. My lord, I've been locked out of my premises, all my documents, my passport, everything is there.
Before the tribunal.
My lord, we had approached the tribunal. Thereafter, matter went to the magistrate under section 14, passed an order again on a false undertaking that the premises is vacant.
Tribunal.
My lord, may I take a chance? Because from section 14, lordship, I'll have no remedy.
No.
I agree, lordship, there's a question of maintainability, but may I take a chance? Because we are there on the streets, lordship, virtually living in
Take a chance, you
relatives.
go before there.
May I
No way.
permitted to mention one matter?
As my lord.
For the urgent motion, your lordship, my firm is selected as a L1 bidder in the Bengal Archery Academy for providing for the food and supplies. Already the work order is cancelled without giving me an opportunity of hearing or neither giving me a show cause notice, your lordship. And they are L2 bidder is working in there, your lordship.
Yes, if they are working, what can be done now?
Your lordship, I didn't give any show cause notice or neither giving me an opportunity of hearing, your lordship.
Where is the matter?
Matter is listed on in the monthly list, your lordship.
There's nothing doing. Monthly list, you should have come in proper time.
May I permit to mention today's item number 45. This is EWS certificate issuance, lordship.
Yes.
Now, lordship, if the matter is cannot reach in the first half, if you lordship kindly take up any time in the second half, lordship.
No, second half possibly hearing matters will be taken up.
May I come at lordship 1 p.m. lordship, because 30th is the counseling and Monday, lordship, I have some difficulties because my Jetu Shraddha Anushthan is there, lordship, on Monday.
Item 43.
45, lordship.
45. You bring your other side at 150.
I will
Let us
inform
see.
lordship, Mr. Vishwapatam Basumulli is other side.
See, let's see. Yes.
Come at lordship 1 p.m.
115.
My lord, this writ petition is appearing at my instance. My lord, if my ladyship takes the last order, my lord,
Extension of interim order.
yes, yes, my lord. The point, my lord,
Mr. Banerjee is appearing on behalf of the state. I will make submissions on his instructions, Lordship. The issue is pending before the larger bench, my lord, as per instructions.
Yes, it mentions so.
Yes, Lordship.
It has not been decided till now.
No, my lord.
not yet.
No.
Not yet, my
In
lord.
fact, it is pending before two different division benches now. The point is whether, my lord, an
What is the point? Please come. It appears from the submission made on behalf of both the parties that the issues pertaining to the instant writ petition is pending consideration before the Honorable Division Bench. Stuff next. In view of the above, the interim order that is subsisting is extended till 12th December 2025 or until further order, whichever is earlier. Liberty to mention the matter for hearing.
Deeply obliged, my
I'm
lord.
grateful.
And for the state respondents.
Lordship, I beg to appear on behalf of the respondent number 652.
So I beg to appear for the petitioner. In this matter, I am led by
appear
Mr.
for the
Rupak
bank,
Ghosh.
Lord.
Sir, I am praying for a short passover. I am led by Mr. Rupak Ghosh in this matter.
Passover will not be possible. If it is to be passed over, it has to be for the day. If you want to start, you can start.
then I
It's up to you.
start.
Please. What is the matter?
Sir, your lordship, my lord, pursuant to your earlier order, directed for filing one supplementary affidavit.
All right.
Lord, this is the supplementary affidavit.
Where is the direction for filing supplementary? I do not see any.
Earlier order.
এটা কোনটা দিনেশ কুমার জয়সওয়াল তো? There is no direction. I do not.
But I appeared, your lordship will decide that, my lord, your lordship will allow us.
That means it was just orally. I just might have mentioned. I do not remember. What is it? What
But
exactly?
the item number 3 is where your lordship passed the direction because only item number 3 was taken up. For 3, no, the direction was only because the other two matters were not taken up on that day. So maybe I do not know, my lord, whether it was recorded.
What is the issue?
But the issue is, my lord, the bank has, my lord, I am a tenant in respect of a property. My lord, I have tenancy, I have possession, I have all those documents. The prior tenancy prior to mortgage. Bank has not obtained an order under section 14 of the magistrate to take possession. Now, this supplementary becomes very important because there we have now obtained the copies of the affidavit filed by the bank and the order passed, where Milord Bank on affidavit before the magistrate has said no tenancy exists. That's number one. Number two, my lord, your lordship knows those two judgments of Supreme Court where Supreme Court has said, my lord, this servicing proceeding cannot be used as a tool to override the Rent Act and throw out a tenant. And last I apprehend an argument will be made that this is not registered lease. But even two recent judgments of Kalasari and the other Bajrang Lal, my lord, clearly says even if it is not, my lord, a registered lease, then also the tenant has a right to prove an oral lease and it cannot just be wished away. But if those are the circumstances, how can the bank, by my lord, making a false statement on oath before the magistrate, obtain an order for possession? And my lord, very important, already the original borrower or the guarantor against whom, my lord, the bank is proceeding, I am not the borrower or the guarantor. They have obtained an order of stay in a civil court. So bank is not proceeding against them. Bank is only, my lord, now hell bent on proceeding against the tenants. And I am one of such tenants.
No, but then if the borrower has got a stay, then how can the bank proceed?
Yes, my lord, that's for them to say. Well, possibly the suit that they have filed, I do not know. But the suit that they have filed, they've only restricted themselves to their portion of the property.
All right. That means the
Possibly,
tenanted
but I really am
tenanted portion is
yes,
not there in
yes,
this.
possibly not there. Well, that is the difficulty. Now, well, you are not proceeding against the main person, the guarantor, who is my landlord, but you are proceeding against the tenanted portion. And that too by making a false
Guarantor
statement.
is the landlord or the borrower?
The guarantor is the landlord and the borrower is somebody else. So, my lord,
Somebody else means?
But I do not know. My lord, the landlord, my landlord whose property I am in, my lord, he has guaranteed somebody's, my lord, loan or
All right.
and my lord, as such, my lord, bank is proceeding.
All right.
Kindly visualize my situation.
Hmm.
Kindly, if your lordship takes the supplementary affidavit. Well, that
Did
should
you
be-
serve copy?
Yes, yes.
Yes,
Served
sir.
on the bank.
My lord, yes, we have received, my lord. Last occasion, I have submitted the sanction letter, my lord.
I will hear you. Let
My-
him place his case.
My lord, my lord.
Yes.
Well, kindly takes the supplementary, my lord, once. My lord, kindly, my lord, come to my lord, page, my lord, 22.
Yes.
Kindly see the affidavit of the bank, paragraph 2. There is no tenancy agreement available as branch record in the mortgage property. However, there is no rent agreement submitted available in the branch.
Hmm.
That there remains no stay injunction order from any competent authority. This is also false.
Hmm.
Because, my lord, in the borrower, in the guarantor suit, already an injunction is there. Now I come to know. That is also,
But then not in respect of your portion of the property, isn't it?
my lord, that maybe, my lord, I do not
Then-
know what is the schedule that the bank is claiming here. My lord, if this is the, my lord, and then, my lord, your lordship knows, my lord, that 9-point checklist which Supreme Court has said
Yes.
that the magistrate has to follow. That obviously, my lord, this is wrong. If the affidavit is wrong, then naturally the, my lord, magistrate's 9-point or 7-point, my lord, checklist has to be wrong.
Page 20
Yes, my lord.
of the supplementary, the borrower has created serial number 3.
Yes, my
Has
lord.
the borrower created security interest over various properties? Is your property mentioned over here?
But this is the part of my tenant. This is
Which portion? All that piece and parcel of land?
Yes, my lord.
4 kata, you are possibly not the
Not
tenant
entire,
in
my
4
lord,
kata.
my tenancy is in portion of the, my lord, kindly takes my tenanted, my
Be
lord,
the
the
state
receipts that I have.
memorials containing deed such and such. Well, 34 Wellington Street. Changaritola Lane comprising holding.
Lord, kindly takes my memorandum, my tenancy agreement in the main writ
G
petition.
plus 5-story brick built building.
Yes, my lord.
Owner of the property, Messrs. Maxofit Softtech.
नहीं ये तो schedule था यही my lord, my agreement is annexed at, my lord, page 20 and the schedule is at page 29. This is ground floor of, my lord, 70 Ganesh Chandra Avenue. G plus 5, I am at the ground floor, my lord. And my area is clearly shown in my agreement, my lord. If your lordship, my lord, takes up, my lord, the my agreement, and my lord, agreement is dated, my lord. Agreement is dated, my lord, 1st day of December 1993.
Yes.
Much prior to the mortgage. Much prior to the mortgage. And my lord, not only that, my lord, I have shown, my lord, all documents pursuant, my lord, which will show, my lord, that I am in possession. Page 30.
What is page 42? Mewalal Jaiswal.
Page 42 of, my lord, writ petition.
Writ petition
Yes, my lord.
versus Maxofit Softtech.
My lord, this is the suit filed by the guarantor, the original landlord. Sorry, my lord. I'm sorry, my lord. This is the suit filed by us to restrain the landlord. But that does not, my lord, has anything to do with the bank. This, my lord, kindly see the order, page 42.
Yes.
Yes.
Followed
Adjournment
it.
is hereby considered and allowed, defendant
Uh,
opposite party from
Followed it.
interfering with the peaceful possession.
All right. What are the judgments that you
Yes,
are relying
madam,
upon?
kindly see.
Please show.
First is ये Vishal Kalasaria. My lord, may I first cite, my lord, Vishal Kalasaria. That is, my lord, 2016 3 SCC 762. 2016 3 SCC 762. My lord, kindly takes paragraph 30, 35 and 37 of this judgment. My lord. 30, 35 and 37.
Yes.
But the issue of, may I quote, my lord? The issue of determination of
37. Come to
30, my lord,
37.
paragraph 30. 37 is also clear. My lord,
Yes.
absolutely clear. My lord. And, my lord, also, my lord, 30, because this, my lord, goes to, my lord, the registration.
Hmm.
My lord, paragraph 30, that's why I'm saying, because I'm sure they will take that point, my lord, that's why I wanted
Yes.
to place. The issue of determination of tenancy is also one which is well settled. 106 of transfer of property does not provide for registration, does provide for registration of leases which are created on a year-to-year basis, which what needs to be remembered is that the effect of non-registration of the creation of tenancy by an oral agreement. According to 106 of the Transfer of Property Act, a monthly tenancy shall be deemed to be a tenancy from month to month and must be registered if it is reduced into writing. The Transfer of Property Act, however, remains silent on the proposition of law in cases where the agreement is not reduced into writing. If the two parties are executing their rights and liabilities in the nature of a landlord-tenant relationship, and if regular rent is being paid and accepted, then the mere factum of non-registration of deed will not make the deed itself nugatory. If no written lease deed exists, then such tenants are required to prove that they have been in occupation of the premises as tenants by producing such evidence in the proceedings under Section 14 of the SFIO Act before the learned magistrate. Further, in terms of Section 55(2) of the special law in the instant case, which is the Rent Control Act, the onus to get such deed registered is on the landlord. Of course, that deed is that Rent Control Act is different. In the light of the same, neither can the landlord nor the banks be permitted to exploit the fact of non-registration of the tenancy deed against the tenant. This is what I'm. And my lord has read my lord 37. It cannot be used to evict without following due process of law. And my lord 35, your lordship has seen, does not override the Rent Act. Now, my lord, kindly, my lord, may I now cite Bajrang Shamsundar, which is my lord 2019 9 SCC, page 94.
Thank you.
My lord, this, my lord, I am citing, my lord, paragraph, my lord, 18, 22.2 and 22.3 and 29.1. Kindly make some note.
94.
94. 2019 9S.
Paragraph 18, my lord.
Yes.
Very important, because the chief metropolitan magistrate has to be satisfied whether the valid lease is there. Now they have, my lord, made a statement that no tenancy exists. So where is the question of the magistrate being satisfied? Kindly see paragraph 18.
But then under section 14,
Yes,
the
ma'am.
magistrate does not have any adjudicatory power.
I bowed out. But my lord, based
Take
on
care of this.
it may not be based on the false statements of the bank, then my lord, that satisfaction of 9 point my lord, of the test also does not come. That's why I'm saying kindly see paragraph 18 what the Supreme Court says. The court further held that if the chief metropolitan magistrate is satisfied that a valid lease is created before the mortgage and the lease has not been determined in accordance with 111 of the Transfer of Property Act, then he cannot pass an order for delivery of possession of the secured asset to the secured creditor. Supreme Court says this. In case he comes to the conclusion that there is no valid lease either before the creation of the mortgage or after the creation of the mortgage satisfying the requirements of 65A of the Transfer of Property Act, or even though there is a valid lease, the same stands determined in accordance with 111 of the Transfer, he can pass an order for delivery of possession of the secured asset to the secured creditor. So the satisfaction has to be there. Now, my lord, kindly sees, my lord, very important, 22.2. While a yearly, may I quote, while a yearly tenancy requires to be registered, oral tenancy can still be proved by showing that the tenant has been in occupation of the premises before the magistrate under Section 14 of the SFIO Act. And 22.3, the non-registration of the tenancy deed cannot be used against the tenant. For leasehold rights being created after the property has been mortgaged to the bank, the consent of the creditor needs to be taken. Nothing here, no consent taken from me. And 29.1. I'm sorry, my lord, 24.1. I'm so sorry. I'm 24. If a valid tenancy under a law is in existence, even prior to the creation of the mortgage, the tenant's possession cannot be disturbed by the secured creditor by taking possession of the property. The lease has to be determined in accordance with Section 111 of the Transfer of Property Act for determination of the lease. As the existence of a prior existing lease inevitably affects the risks undertaken by the bank while providing the loan, it is expected of the bank creditor to have conducted a standard due diligence in this regard. Where the bank has proceeded to accept such a property as mortgage, it will be presumed that it has consented to the risk that comes as a consequence of the existing tenancy. But the deepest of records, that is the law. If you have yourself, for some reason I do not want to specify here, have given the borrower or the guarantor a loan based on a property which is heavily tenanted, then you run the risk of taking possession without disturbing my possession. That is the law that has been clearly reiterated in two judgments. Your lordship has also had the occasion to, yes, please, had the occasion to deal with a similar matter, my lord, although probably not decided finally. Dilip Malakar, copy the doctor, versus my lord, the state of West Bengal and others, WPA number 3344 of 2025. Lord, possibly lordships, my lord, disposition of mind has been also been similar. My lord, may I just quote my lord, few portions of this? Notice was issued, paragraph 2, dated 20th January, issued by the authorized officer of the Union Bank in respect of property of such and such. The notice was issued by the bank for taking possession of the property, which was mortgaged to the bank. The petitioner claims, paragraph 4, to be a pre-mortgage tenant in the suit property comprising of 160 square feet of considerable period of time. A title suit in respect of is also pending. The petitioner apprehends that relying on the order passed by the district magistrate on such and such, the bank may take steps to dispossess. Prayer has been made to restrain the bank. The learned advocate appearing on behalf of the bank raises an issue with regard to maintainability in support of his submissions, he cites CELIR LLP reported in 2024 to SSC 1. It has been submitted that the petitioner ought to approach the debt recovery tribunal for relief. Then, my lord, section 14 has been quoted.
Yes, yes.
Your lordship has, my lord. Kindly come to paragraph 14. It is, however, made clear that it is open to the bank to take steps in the matter, but without dispossessing the petitioner from the tenanted premises. Possibly, your lordship's disposition of mind is also similar. My lord, here I have a better case because, my lord, the affidavit is false. Bank cannot justify filing this affidavit that no mortgage is there, no tenant. I'm sorry, no tenant is there. If the affidavit is wrong, the magistrate's satisfaction has to be wrong. And, my lord, clearly, my lord, Supreme Court says even if it is not registered, court has to protect such tenancies. And, my lord, you cannot just wish away the tenancy rights under a special statute when you have run the risk of giving.
All right. Yes.
My lord, I have submitted the sanction letter on the last occasion, my lord. It is with my lord, may kindly take up the sanction letter.
Sanction for what?
Sanction of the loan, my lord. I am the borrower, my lord.
Dekhi.
Borrower.
I don't see anything on record.
I have filed it on.
Was it in this matter or in?
My lord, in these three matters are analogous, my lord.
Oh.
But I'm appearing in only, my lord, 4 and 5. 4 and 5. 3 and 4. I'm sorry, my lord.
Perhaps the last matter, my lord, on
Maybe.
last occasion, I was able to submit that sanction letter, my lord.
But I was there throughout in all locations. I don't think, at least I haven't got it. You may have given it to the record.
Yes.
My lord, kindly take page 3 of the sanction letter bottom.
Yes.
My lord, this is the property description, my lord, while sanctioning the loan, my lord. EMTD of G+6 storied commercial building in the name of Maxofit Softex such and such. Area of land is 4 kata, 3 chitaks and 13 square feet more or less. Construction area ground floor 2830 square feet, but tenancy portion 999 first floor. So my lord, finally my lord will find out total tenancy area is 6109 square feet and such. Now my lord, we have also the action taken by bank, my lord, under section Surface Act, my lord. This is under challenge before the DRT by us, my lord. That matter is sub judice, my lord. Similarly, bank has also filed one section 19 application under the RDB Act that is also under challenge, my lord. So we have challenged this before the DRT, my lord.
And there is a stay.
No, my lord, no stay. Pleadings are complete, my lord. It is on the further because there was no urgency. Tribunal was opinion since there is no urgency. This happens since meantime, my lord. This CJM or learned CJM's order comes in the meantime, my lord. Pleadings are complete, my lord. So it is posted for final hearing, my lord.
Is the bank taking any steps?
Yes, my lord. Bank is contesting the matter.
No,
One bank
Contesting is all right.
Went to the section 14 order, my lord. If that's your lordship's query, yes, we will be. Till today, we haven't. But I'll show, my lord, that on the contest of it, my lord, this application that they have filed, my lord, this is not maintainable.
All right.
And my lord, if
my lord,
that
challenge
sanction
the
letter is
CJM order, I
correct,
have filed one interlocutory application before the DRT also.
All
but
right.
if the sanction letter, what has happened, addressed, handed up to your lordship is correct, my lord, then my lord, if the bank itself has said that it is subject to tenancy, then my lord, that affidavit is absolutely contrary to their own sanction letter.
All right. Yes.
But at the very onset, my
Are
lord,
you aware of the sanction letter that has been handed?
yes, I'm aware of the sanction letter, but I'm not conceding that we were aware of the tenancy. My point is very limited.
Not
Today-
aware of the tenancy because this is very important.
No, but this
The
couldn't be-
sanction of loan mentions about the tenancy.
The tenancy. I understand that. But my only grievance is with respect to the maintainability of the application. Whether they are a tenant which is pre-mortgage or whether they are post-mortgage or whether they are not a tenant at all.
Hmm.
That entire issue, my lord, will not be, my lord, redressed before the writ court. Lordship will
Yes.
kindly take up, my lord, section 17 of the SFIO Act once.
Yes.
This entire issue has been provided under the statute,
Yes.
under section 17. So,
Hmm.
section 17 that any aggrieved person can file. Lordship has, my lord, held in several orders. Lordship will kindly take up section 4 capital A. I'll show 3 judgments, my lord, of this court. 4 capital A,
Hmm.
where any person in an application under subsection 1 claims any tenancy or leasehold right upon the secured asset. The Debt Recovery Tribunal, after examining the facts of the case and evidence produced by the parties in relation to such claim, shall, for the purpose of enforcement of security interest, have the jurisdiction to examine whether lease or tenancy has expired or stood determined, is contrary to section 65A of the TP Act, is contrary to terms of mortgage, or is created after the issuance of notice of default and demand by the bank under subsection 2 of section 13. Therefore, under D, before will also be covered. So, my lord, this entire issue, my lord, the section 17 authority, that is the DRT, is more than competent to, my lord, hold and adjudicate. Today, a writ petition is not maintainable at all for principally 2 grounds. Number 1 is whether my affidavit under section 14 is a false affidavit with absolutely frivolous allegations and lies, or it is an absolutely true affidavit, and whether the sanction letter, my lord, covers the tenancy or not, is not an issue that will have to be redressed before the writ court. Lordship will, my lord, kindly take up, my lord, one order passed by this court.
I was just thinking, let everybody know that since the issue is already pending before the tribunal, the landlord has already approached the tribunal, and the steps that will be or that is being taken by the bank will also is coming up by way of an interlocutory application. Why don't you go before the tribunal and get everything?
Give me some protection
No.
till the time I reach, because this, Lord, I can satisfy.
No,
your
by
lordship.
one day the bank will not be
No,
able
it's not a question
to
of- my lord, it's not a
get
question
hold of the.
your lordship has been this side also. But going there, filing an application, whether the court presiding officer will at all say it, will take up. Give me a week's time.
No, I'm opposing that. I'm opposing that.
If I get into
Very well.
this
Week's
a
time
shortcut
is all
method,
right.
but
Please
if
stop.
I can.
Well, I'm opposing that on principally one, if the application is not maintainable,
Alright,
otherwise, can an interim order at all be passed
All
protecting
right.
them?
If he wants to oppose that, I will argue.
Because your lordship returns that finding, your lordship will give me 30 seconds before lordship dictates that order.
I am not returning any finding.
No, because-
Only I am sending it back to the tribunal, not back. In fact, I am giving them leave to approach the tribunal because the issue is already pending before the tribunal.
Lordship will not pass any interim order.
All right.
Some protection,
see.
otherwise, complete blatant lies is being told.
So
by
they'll
the
take
bank.
that point before the DRT.
I can satisfy your lordship.
So I can satisfy
The
it's not
petitioner
maintainable.
claims to be a tenant in respect of a property where order has been passed under the provisions of the SFIO Act in favor of the bank for obtaining possession on account of non-payment of the loan amount. Stop. Paragraph. The sheet anchor of the petitioner's submission is that the petitioner is a pre-mortgaged tenant. Stop. The bank obtained order under section 14 of the SFIO Act, completely suppressing the fact of tenancy. Stop. Next. The landlord, prayer has been made to set aside the order passed by the magistrate and the steps taken by the bank to oust the petitioner from the tenanted premises without taking due recourse to law. Paragraph. Learned advocate representing the landlord submits that an application under section 17 is pending consideration before the Debts Recovery Tribunal. Stop. Interlocutory application will be filed by the landlord before the tribunal challenging the order passed by the magistrate under section 14 of the Act. Stop. The landlord admits the petitioner as a pre-mortgage tenant. Stop. The loan agreement has been produced before this court, wherein it has been mentioned, wherein the fact of tenancy is mentioned. Stop. Next. Learned advocate representing the bank submits that the writ court does not have the jurisdiction to decide the issue. Stop. Provision of section 17 within bracket 4 of the Surface Act has been relied.
But 4 capital A, my lord.
4 caps A. 4A. 4A. 17 4A. 4টা কোথায় গেল? Surface Act has been relied upon. Stop. It has been submitted that the petitioner may approach the tribunal for relief, but the writ court is not the competent forum to adjudicate the issue of tenancy. Paragraph. Upon hearing the submission made on behalf of all the parties, it appears that, admittedly, an application under section 17 of the Surface Act at the instance of the landlord is sub judice before the learned tribunal. Stop. The petitioner claims to be the tenant under the said landlord. Stop. Paragraph. The petitioner has documents to prove that the petitioner is a pre-mortgage tenant. Stop. It will be open for the petitioner to approach the tribunal for necessary relief. Stop. In the event the petitioner makes an application, the same shall be decided by the makes an application. The tribunal shall endeavor to decide the same at the earliest. Stop. The at the earliest, preferably prior to the execution of the order under section 14 of the Surface Act is made. Writ petition stands disposed.
Lordship will not make that recording, my lord. If Lordship does that,
I have not done anything.
so there'll be a timeline foisted upon me to make that exit. If I go to the and take physical
It is
possession,
upon the
I
tribunal.
can make whatever some you take it before the appropriate court. You won't file a divorce proceeding before the DRT.
Very vociferous.
Lordship,
Writ court's power are never.
No, it's absolutely curtailed. I'm showing orders. It's curtailed. I'm showing us.
No, it's only because the issue is pending.
Yes,
You are relegated.
So, my lord, there cannot be any interim order upon me to
There
enforce
is
that
no
order.
interim order upon you.
My lord,
I have only recorded that the tribunal will endeavor to dispose of prior to section
Very well.
14
May I
execution.
pray for one small indulgence? Lordship records the usual paragraph, my lord, that because the affidavits have not been called for,
Yes.
this is the allegations made in the writ
Yes.
petition are deemed to have been
As
denied.
the writ petition is being disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
I'm extremely grateful.
Insisting on that, my lord, may I insist on another, my lord, very important aspect. The order is passed on 4th of October 2024. We did not.
Which order?
The order of the magistrate. Now, my lord, there he will go and say, but this is hit by limitation, my lord, let that be recorded. He's saying that if
You can always go and approach the tribunal with your section.
Kindly record that the bank says, my lord,
Section 14
whatever is
applies
there
of the
is there.
Limitation Act.
he will go and say that, my lord, I'm sure, my lord, he'll go and your lordship knows.
If there is a point in favor of the bank will always.
Then, my lord, my writ petition, my lord, completely, my lord,
But there is no
Nothing.
limitation on filing an intervention application.
conscience that your lordship has jurisdiction under the writ
No.
petition. But
Next.
then I will be non-suited both ways.
No.
That the presiding officer there will say it is hit by limitation and they, my lord, will execute the order despite making a, my lord, false statement on oath.
Yes. Next one is also same possibly.
My lord, I am not appearing in that
But
matter.
I'm only appearing for 3 and 4, my lord.
3, 4, 5 similar matter.
For 5, I'm not there, my lord.
Different tenants in same property.
1 minute. Just now item 3 was taken up. Who is there in 4? Are you there for the petitioner?
4 I am for the petition.
All right.
Same property,
Same?
different portion of the tenancy.
All right, then same order can be passed. Check the appearances. You are there in 4?
I'm there in 3 and 4, my lord.
Yes.
Extremely grateful.
5?
Same.
5 is also same. All right, same.
Different
Five-
tenanted portion of the same property.
All right, but 5 you are not there for the bank. Is it a different bank?
No, my
Same
same,
bank.
Same bank?
same bank.
How can you?
Neither is my advocate on record this. I'll not take that upon myself.
So let that there
Very
be
well,
a
then-
separate order in that matter. We
Eh,
can't-
in-
it is not represented.
In that case, ওখানে কিন্তু লিখে দেবেন none appears for the bank in item number 6. না 6 না 5. 5 এ none appears for the bank. আর যেখানে যেখানে ব্যাংকে সাবমিশন আছে 3 and 4 এ সেটা 5 এ হবে না।
Then I will pray for some orders in that bank is not there, my lord.
The
They're not
secured asset is
Why
the
do
same.
not,
I'm not.
please do not open your mouth.
I'm
You're
sorry.
not.
I'm sorry.
এটা ভুল হবে। এটা এই অ্যাপিয়ারেন্সটাও চেক করে নেবেন। এটাতে ওনার অ্যাপিয়ারেন্সটা রেকর্ড করা যাবে না আগের দিন। ইট ওয়াজ রংলি রেকর্ডেড। এটাকে লিখে দেবেন অর্ডারে যে ওনার অ্যাপিয়ারেন্সটা ভুল করে লেখা হয়ে গিয়েছিল 16th আজকের অর্ডারে। Five
And the supplementary affidavit may be taken.
supplementary affidavit is taken.
Direction is there. Your lordship's direction in item number 3 is there to file the supplementary affidavit. I'm just shown the order.
No, 3 I didn't see the direction.
Kind ball order.
3 তে কোনো direction আছে supplementary?
That order dated
Oh, in the last order.
22nd July.
Yes, it's there.
One thing we will not make any, at least I will not make any incorrect submission.
No, I didn't see it.
Grateful, my lord.
Learn from the best.
Milord, willful default, Milord, challenge, Milord, show cause notice,
Which
identification.
your other side?
The Milord, we have filed the affidavit of service. It's showed delivered.
Which bank?
R1 is
Milord,
Union India, R4 is the Punjab National Bank.
Punjab National Bank. Delivered. There's a unique case where, Milord, show cause notice, identification committee order, review committee order are verbatim identical, covered by Milord judgment that this is non-application of mine. Milord, is it your lordship's pleasure that I give another notice and come?
Otherwise, it becomes difficult in
Yes,
their
sir.
absence.
I don't, Milord, mind.
Nobody's
May I come back on?
there online also? Nobody's there online? Nina? None appears on behalf of the bank, Punjab National Bank. Let a further notice be issued. দেখি আগেকার নোটিশটা একটু দেখি।
The 5 কোনটা বলতো?
The 5 names, sir.
The track reports are not there. It's only the postal receipts that have been annexed to the affidavit of service.
Have the tracking reports.
What does it say?
Milord,
1 and R5 have received.
respond number 1 and 5, item 4, item delivered. Review committee, it's been delivered.
A review committee is in Delhi.
Yes, but Punjab National Bank at Himanta Boshu Sholoni has to be delivered.
Yes, that is the reason nobody is here.
Milord, kindly Milord,
Yes.
keep it on the next day.
Achha, none appears for the respondents. Stop. There is no proof of service of the writ petition upon the respondent number 2. Stop. Let further notice be served upon the respondents. List next Friday.
Your Ladyship, I appear for the petitioner. Your Ladyship, yesterday this matter was mentioned by Mr. Jishnu Shah, but Your Ladyship, unfortunately, he felt very sick yesterday at night and has been suffering from fever since the morning. So he has kindly, no. So he has kindly prayed to keep this matter on Monday, Your Ladyship.
I don't know.
No, my lord, we can't, my lord, if he's, but I thought he's in court.
Your lordship is down with high fever, your lordship.
Very well. So, Lord, there's no question.
On
Not
Monday,
today.
Milord, we'll ask for Milord an order of dismissal of the whole writ petition because this is in total abuse of process.
Sorry, my lord.
Total abuse of process. Please keep it on Monday. Milord,
Yes.
we'll come.
Lord, Mr. Shah had mentioned this matter yesterday.
Hmm.
He's down with an extreme severe chest infection and high fever.
Hmm.
Lord, I could have done it, but he's my leader.
But how do you expect him to come on Monday if he's so unwell?
I think he will be, he's already started his antibiotics. But it-
Antibiotics course will continue for 5
5 days, but
days.
5 days.
But Lord, that's what he
5
told me.
days.
That's
Then
what he
Milord,
told me.
On the
In fact, you are supposed to do an arbitration before Mr. Chaudhary.
Whatever. Then
Monday, Tuesday, any day.
Tuesday, no. Tuesday, chhada.
no, আমি ও নেই Tuesday.
Plus Monday.
Wednesday, Thursday,
Wednesday.
Friday, whatever, Malad, convenient.
Wednesday, my lord.
Wednesday.
Wednesday. It will give him.
Wednesday. No Wednesday, Your Lordship.
Monday,
Wednesday.
any day, my lord.
Thursday.
Lordship wants to keep it on Wednesday. Not a problem. I would, Mr. Shah,
Wednesday.
informed me Monday.
Acha, NCLT.
Somebody is saying something.
Mr. Banerjee, on Wednesday, we have
Yes,
matters.
yes. Monday, your lordship can keep it, or Wednesday, whenever your lordship wants to keep it.
Thursday.
Whenever I'm keeping it, I'm
Only
telling your lordship.
request is, my lord, let it be understood that pendency of this matter should not be cited for an adjournment before the NCLT, where the resolution
In fact,
plan
that
is
is
up
what
for
exactly
approval.
your lordship remembers everything.
This is what it was mentioned
Yes.
yesterday, and
That
the matter was picked
taken up today.
This is only, Malad, a small issue, Malad, with regard to, Malad, the resolution plan.
So I'll
I
tell
do not know. I can make it only not today. See
Yes.
what happens on Monday.
Very,
Yes,
yes,
great,
yes,
That's
great,
better.
great,
Obligement. Obligement.
very grateful.
Adjourned on the prayer of the petitioner.
Grateful, Malad.
I'm grateful. ওখানে খালি গিয়ে time.
Lord, on behalf of the private respondent, my lord, I am praying for 1 day accommodation, my lord. Mr. Moinak Ghosh is appearing, he has not come. Only 1 day accommodation, my lord.
Who is for the petitioner?
Mr. Sen was appearing. Mr. Shakur Sen was appearing for the arguments were commenced.
Award.
Yes, my lord.
Yes.
MSME.
MSME award. Very well. Adjourned on the prayer of the learned advocate representing the private respondent. Adjourned for the day. Next.
I am appearing on behalf of the petitioner, your lordship. This is a hearing matter, your lordship. I am led by Mr. Bachawat. So,
Lordship,
your lord
may I-
kindly take.
May I submit, Lordship, we are suffering an interim order, Lordship. We had mentioned this matter on earlier occasions. Also, several accommodations have been sought on a similar ground.
Why don't you start?
Take some time, your lordship.
Yes.
It's almost 11:30. That's
Yeah, that is all right. But then hearing matters takes up this much of time, and it is taken up around this time.
Your lordship kindly takes it up on Monday, your lordship.
Lordship, this matter may kindly get some precedence, Lordship. I'm being followed up every day by my client because this involves a huge stake.
দেখি কি আছে এক মিনিট।
Huge stake. Lordship, today what is primarily in dispute before your Lordship is the classification of NPA.
You are the bank?
Yes, Lordship. I appear for the Indian Bank.
Well, this is a consortium of bank. The lead banker SBI. The matter is already pending. with this
Specifically
Supreme Court.
for SBI and for Punjab National Banks, there was similar kind of proceedings taken out by them. Before the Honorable Division Bench of this Honorable Court had upheld the classification of NPA, they had approached the honor and
Stayed, your lordship.
may I on condition of payment. They are making payment. The assets by SBI has already been transferred to an ARC. The Indian Bank had also taken out a similar kind of advertisement where they also intended to transfer the assets to the ARC. That was stayed at the relevant point of time by this Honorable Court. But in case of SBI, the transfer has been held as valid. They have approached the Honorable Supreme Court. They are making payments and that too of huge amounts. Even in respect of Punjab.
In respect of Indian Bank, you are not getting any payment.
In respect of PNB also, they have also the Honorable.
Pilot, they have preferred an appeal against the interim order. They have subsequently withdrawn the appeal from the division bench.
That is on a completely on a different aspect. Lordship, we will make our submissions on that because the advertisement today is infructuous. The bank has not taken out any further advertisement because the NPA classification itself is under challenge on this date, Lordship. And the PNB also, they are making payments pursuant to the Honorable Supreme Court's order.
But for Indian bank, this matter is pending in this situation, Lordship, and the bank is suffering. And the amounts which are being paid are in huge tunes. They have made submissions before the Honorable Supreme Court. I have that order where they say we are trying to obtain loans and try and pay all the banks. There is no payment coming forth through Indian bank. The
And
classification.
Indian Bank is also a party
No,
before the
Lordship,
Supreme
Indian,
Court. It's not there.
the writ petitions are different. The appeals are
right.
separately being preferred. And the NPA classification here, Lordship, we will be making our submissions. We'll substantiate the classification. That is all the moot issue, Lordship.
My lord, I am being led by Mr. Proceeding.
That is
Yes.
that. Sorry, Millard. That is the moot contention, Millard, whether there is an NPA at all in the dialogue law. If there is an NPA, Millard, then Millard, that question is pending before the Appellate Court. Otherwise, Millard, the reasoning given in the Millard interim order, Millard, is still holds good. So, Millard, if your Lordship holds that there is an NPA, Millard, then I will submit, Millard, and I'll show to your Lordship, Millard, that that's exactly the issue before the court. Here the issue was, Millard, to declare an account as an NPA, you need a default of more than 90 days. Now, Millard, we have been able to demonstrate, as Millard, it will appear from the interim order that is subsisting in this writ petition, that this time of 90 days had not lapsed. But Millard, there were three banks who were Millard in the consortium. The lead bank was probably State Bank of India. All of them suffered the same fate, that there was 90 days period had not lapsed.
But some payment is being made to the other banks.
That is, Millard, pursuant to the orders of the appeal court, without prejudice to my rights and contention that there is no NPA.
All right. So why don't you make
Millard,
payment to the Indian bank
Millard,
also?
Order, Millard, holding, there was NPA has been stayed by the Supreme Court.
Unconditional.
And one of the appeals, Millard, is an unconditional stay. So, Millard, your Lordship will have to decide.
No, that is all right. But the submission of the bank is that the other banks in the consortium is receiving some payment, but the Indian bank is not getting anything.
Millard, it's not question of getting anything, because the thing is this, Millard, their right to get is governed by the statute. My right to obligation to pay is also governed by the statute. I am paying pursuant to orders of court, on the condition that I am staying the order. Now, Millard, in my respectful submission, Millard, my learned friend won't be able to demonstrate before your Lordship, Millard, that the interim order, the reason given in the interim order is incorrect. So, Millard, let my learned friend first show, or Millard, if your Lordship is willing to take it up tomorrow or any day, Millard, when we come and address the court on that issue.
No, it is the matter is ready for hearing.
Yes.
Your junior prayed for adjournment.
Oh.
On the ground of Mr. Pachawat.
I'm sorry.
No, it's all right. But then this is the position.
So can I just give your Lordship, not take 1 minute? I know your Lordship has other benches. That two things before your Lordship in this matter. Not there is a declaration of a NPA. Now, very clearly, Lord, as has also been held in other matters, Lord, they cannot show it's a NPA. Now, in the meantime, the writ petition was filed, not challenging a particular notice. Since the writ petition has been filed, not that notice has been withdrawn. Now, the court records in that order that that issue is now gone. But since we are praying not that the declaration of NPA is itself wrong, this is the issue to be decided. So it's perhaps just an academic question now. Now, my lord, that is what is to be decided by your Lordship. My lord, there are various forums before which proceed.
Then, if it is only the issue of declaration of NPA,
yes,
in that case, what is the problem in paying off the dues of the bank?
Lord, I tell your Lordship. Lord, the bank's dues arise only if not the declaration of NPA is held to be not correct, if it is upheld. If the declaration of NPA is incorrect, then the money won't be payable. Now, the same issue is also pending, that they filed proceedings before DRT and other forums. Those issues are pending. But the notice itself, which was the subject matter of this particular writ petition, has been withdrawn by them. That's recorded in the order. So, my lord, now it's purely an academic question and an interesting one. It's an interesting one, no doubt, my lord. And your lordships will decide that, my lord, or my lord, if your lordship feels DRT will decide, DRT can do so. But my lord, they have said that they've withdrawn
At the proceedings under the Surface Act.
Yes. Lord, they had issued a notice They had issued a notice that was not followed up by them. Instead, not proceedings were filed in DRT.
13-4 correctly. Therefore, I don't. 13-4.
Then what is to be decided over here?
13-4 হয়নি, I
Not, not I tell your lordship, not your lordship must be aware of these judgments. Not they issued a not 13-2 notice. Not they did not take action under 13-4. Now my right to challenge the not NPA before the DRT is only not dependent on a 13-4
13-4.
notice. Before that, I can't go.
Right.
I can't go. So I'm not having not
So
failed there or not chased up that 13-2 notice. Not
yes.
they initiated proceedings before the DRT, and then what they did was they suddenly declared me as a defaulter, having become a NPA from 2 years ago. Retrospective declaration as NPA on a date when it could not have been, and on that basis they issue a sale notice. So we came challenge the sale notice before your lordships, and there's an interim order, of course, protecting us. Now, while that was pending, Lord, they tried to not file appeals and other such things, didn't succeed. But then they said that they are not withdrawing the notice. So at the moment, the threat of sale is not there.
Isn't it always advisable to go before the statutory forum, that is the tribunal, regarding the declaration of NPA? Are they taking any coercive step now? Nothing of the sort.
Or let them make that statement that they will not. Lord, I'll go before the DRT in that case. That's the protection that I have at the moment. I have a protection at that moment. Now, at the moment that notice was stayed, Lord, they've withdrawn it now. They've withdrawn it. So it's an admission of sorts that the declaration is wrongful. It's an admission of sorts. No doubt about that. Now, if your lordship wants to go into the legal issue,
Why will the court go into the legal issue? This is what is.
that's what the last order says, but your lordship is right. It could be decided before the body which takes it up. Well, let me take instructions and come back on that. In that case, my learned friend will also take instructions on that. Well, let my learned friend take instructions. I'll also take instructions from that.
Taking instruction, Lord.
Well, that's all right. Then I'll make my submissions.
What has happened is,
But then I'll make my submissions. My writ petition, Lord. It's my.
Yes, yes.
my
Just
learned
wait.
doesn't permit
Yes.
me to
Yes, yes.
react. Lord, there's a notice issued under section 13.2. Post notice under 13.2, Lord, there is an assignment of the debt in favor of a reconstruction company, asset reconstruction company. Now, Lord, the asset reconstruction company.
Lord, there's been no assignment in this matter. My learned friend is mixing it up with another matter.
This was for assignment.
Yes, notice was for assignment. There is no assignment. It was stayed. It was stayed.
Notice was for assignment.
Correct.
This notice
Not
was
to any
for
particular
assignment.
person. It was an auction. The auction was stayed.
That notice is under challenge.
Yes.
So, Lord, the assignment stopped there. And Lord, declaration of NPA is challenged here.
Yes.
So, Lord, the identical issue was there with regard to the other two banks' writ petition,
No, not
which are now, Lord, pending before the Supreme Court. And Lord, the same point was urged that NPA declaration was not proper. And that, Lord, issue traveled by a division bench judgment. Lord, I want to place those judgments. But unnecessarily,
So is it required for the writ court to go into this, or the tribunal can
if
decide?
there is no adjudication today,
Yes.
what they will do is, Lord, they will again file a writ petition the moment, Lord, I issue a notice for assignment. Because this is an asset which is available to me under the SURFACE Act. I need not issue a notice under 13.4. I can just assign my rights in respect of the secured assets in favor of an asset reconstruction company. And next time, Lord, this time it was not done because, Lord, the writ petition was filed in deference to the matter which was pending before your lordship. Lord, we did not, Lord, proceed further after issuing the advertisement.
Not in deference. It's because the notice was
now,
not.
Lord,
Please come, let us see in that case.
this is, Lord, a definite, Lord, proceedings
When?
to avoid payment.
Any day convenient to your lordship.
Any day today was convenient. We've already consumed 10 minutes by only discussing what is to be done.
There was, of course, this possibility, but not since my learned friend is not agreeable. That's not.
Lord, kindly, Lord,
matter will
take
have
the
to be
time,
heard.
Lord, for the purpose. This kindly give it some precedence, Lord. There's a huge amount of money.
It is
which
already there in the top of the list. It has taken up
Lord,
today.
if your lordship, Lord, so pleases, kindly, Lord, take it up, Lord, on a day. Kindly, Lord, assign us, Lord,
No,
that
no,
case.
matter is ready. লেখার দরকার নেই কিছু. It's there in the list. It will appear for hearing.
But I can understand, Lord, a situation where, Lord, my learned friends, I can say that we can proceed further. We can't. Lord, the moment we issue a notice, another writ petition will be filed. And we'll be back to the same situation.
I am for the petition, Lordship. Lordship, I have mentioned the matter for non-prosecution, Lordship. I am with the instruction.
Why non-prosecution? 2025, you filed it in June.
Yes.
Then why non-prosecution?
Lordship, petitioner is not willing to proceed with the said petition, Lordship. I am with the instruction, Lordship.
Not press. Yes.
Great.
I take the of the respondents.
My lord, this is my writ petition. I have today's fixed for extension of interim order, my lord. This is against the one SFIO proceeding that has been initiated against a group of companies, and I am challenging the basis and the opinion, the judicial opinion that has led to the issuance of these notices after an action that has already been taken, which has led to the winding up of those companies. After that recommendation, again coming back and
Why are you not taking steps for getting the matter heard? The interim order is continuing from when?
Your lordship will not, due to the business of the court, your lordship fix the matter on 20th June. Kindly extend the, can you give me some precedence, Lord? Fix the matter. I will not take.
I will not fix. You go and get it heard before any other bench having determined. You see the pressure of the bench.
Lord, I will not take much time, Lord. Your lordship fix any day.
You may not take much time, but then if it is ready for hearing, take steps for hearing.
Ready for hearing, Lord. Bench, your lordship knows, Lord.
Why? There is irrespective of classification and irrespective of years, bench is there. Go down. Here, at least there you'll go down. Here it is nowhere.
There is a chance of hearing in this bench.
It is in front of our eyes. Let it not go down. Let it not go down in the go down.
Kindly fix any day, Lord. I will not take much time.
Fixing date is just not possible. This is the difficulty.
Any day in the next
Very
month,
short
Lord,
question.
short matter, Lord, we have
That's
issued
not
notice, Lord. They have challenged the, Lord, the jurisdiction. Lord, I will not take much time, Lord. Any day, Lord, in the next month, Lord, any day. Lord.
See, the vacations will be approaching. We are approaching the vacation. And if you say you'll be there in a hearing matter,
I will not take much time.
loss for y'all.
Lord, 15 minutes will be okay, so far as I am concerned.
And another 15 minutes for Mr. Mojumdar. 30 minutes. And now the court has to dictate judgment.
Kindly, Lord, kindly next month,
What
any
is
day.
the issue? What is the issue?
But the issue is not with regard to a proceeding initiated under the provisions of
You
the
don't open the file today.
Companies Act. Not it requires not phase-wise report and taking of action by the government. Now, there are certain allegations made by one of the brothers. Not it is also finding place in the report. Not it led
Is
to
the brother a party also?
no, it's
No,
a
not required.
action taken by the government.
Company. All right.
Now, so it went up to a particular length. But the farthest action taken in terms of the report has been initiated. We are contesting that before the NCLT and before the magistrate's court. Now, the question is not whether after having taken a full decision in this regard, a further subsequent action can be taken without furnishing us a copy of the report, number one. Number two, whether this can at all be done. Not, they have taken an action on the basis of this allegation and had gone to this extent. Not, we are contesting the propriety of this action. Not whether they can once again initiate from this process or not, the law bars this, specifically under the provisions of the Companies Act.
Because of the pendency of the writ petition and the interim order, you are not in a position to carry forward the proceeding.
We are not in a position to proceed further. The interim order is there, my Lord. The stay has been granted from proceeding further in the matter. Can you fix, my Lord, any day, my Lord, any day in the next month?
Whether the second phase can be initiated.
No, that is the whether I have jurisdiction or not, my Lord. That is the question, my Lord.
Anyway, the interim order that is subsisting in the matter is extended till 28th of November 2025 or until further order, whichever is earlier. List for hearing in the combined monthly list of August.
Some precedence, Lord.
Let us see. There are so many matters you see.
Or you lost, my Lord. Can you fix any day, my Lord? Any day.
No, day is impossible.
Monthly list of August, my Lord. Then any day, my Lord. Your lordship previously fixed on 20th of June. Any day, my Lord, in the next month. Any day.
That was
June. That was June.
Yes, June.
Lord, any day on in the month of August. Any day, my Lord.
Again, a date will be fixed. It will not be
No,
taken up. What can be done? No, sorry. Next.
কেন আমাকে ইয়ে করে দিল?
Number 3, I'm for the state, my lord. I'm led by Mr. V.K. Shai. He's appearing online, my lord.
Item
My
3.
lord, I'm appearing on behalf of the state, my lord.
Yes.
My lord, I'm for the petition. I'm extremely sorry, my lord. I'm rushing home. Court number 5.
You want to take some breath?
No, it's okay. Lordship, in this matter, okay. Lordship, I tell you, Lordship, what has happened, my lord. On 3/6/10, the private respondent made an application for purchase of a flat.
Show me your affidavit of service upon the respondent number 3.
Affidavit service ta kothay? May I take a short pass and come back because the learned advocate is not here.
All right, pass over. Next.
What to put on?
Yes.
Look, the issue is slightly larger, but for today, I'll make it very concise. I want to make payment to the bank. This pertains to a outstanding amount which bank has foisted on me.
Surfacey.
All right. There's a DRT section 17 pending. I have lost challenging the section 17, the section 14 order. I'm assailing that bit here, but on a different ground. So there are myriad legal issues, but I don't want to get into that today. Not on July 8, 2025, I have given them a OTS proposal. If the bank would
At which stage was the proposal given?
No, proposal I've been giving for the last 1 year. And so there are two things. One, there are two different accounts, and my account is now actually protected or covered by the GLSS, that central government scheme. So under that scheme, they've taken some amount of money. After they've taken the money, they haven't given me credit for that. And I want to make additional payment so that I can settle this issue because the property is valuable for me. I want to pay the money, and if the bank can consider this OTS proposal of July 8, 2025, which I've made, I've paid 10% amount also under that, and upfront I paid 50,000 rupees, which the bank has taken and put in a no lien account.
What is the due amount?
Well, as 13.2 that was given, was about 1 crore 19 lakh.
In 2022.
22, and my OTS
Proposal has already been rejected. This is the proposal and this is the rejection of the proposal.
Give a copy to him also.
Lordship,
rejected yesterday.
yes, it was communicated.
After the writ was served on July 8th, I gave the proposal. 23rd July, they say it's rejected.
Lordship, the proposal also, if your Lordship peruses the proposal, it is that we have to give them the no objection for selling that property. There is a lot of conditions involved which cannot be exceeded by the bank. And this GECL, what has been submitted, this point was taken before the learned DRT. That has been adequately dealt in the order.
That's on the legal aspect. My specific instructions are that the client wants to, he's interested in settling it. Then
but settling it with 10,000 rupees, and you have 1 crore something due
of 75 lakhs. Apart from what has already been taken by under the scheme. My payment is of 75 lakhs. Out of
First, make the payment and then only you can go in with further conditions.
Yes, proposal. May I only pray this? Now that yesterday they have given this rejection,
yes,
and after the writ was filed and my OTS was given on July 8th, would your Lordship allow me to 2 weeks' time to discuss with the bank any subsequent proposal that I can come up with, and I'll try and settle this issue.
It is up to you.
It is up to you. Submission.
Lordship, may I most respectfully submit that this interim application, wherein the learned district magistrate's order was challenged, was heard on umpteen number of occasions.
How much is your due today?
Lordship, it is more in 2022 it was 1 crore 19 lakh.
Yes.
Today's date it will be close to somewhere around 2 crores. And their proposal also, which I have handed over, Lordship will kindly peruse that what is the language in
75.
It's not only 75. The language is that we will have to
No, what have conditions? I'm not looking. I'm looking at the
Yes.
figures.
The-
Final
even the-
settlement amount is 75 lakh.
That is not accepted.
Payment of upfront amount is 50,000. That is 10% of the total settlement amount. Where is the settlement amount? Nobody knows. Receivable
75
amount
lakhs.
95.
Settlement amount is 75 lakhs. and pay-
75, they are not agreeing. When 2 crore is the due, then 75 certainly the bank will not accept.
Then I'll sit with them. This case they have given after they received the writ.
Come.
Sir, kindly record the
Please
petitioner
come.
wants to have a discussion with the bank regarding a proposed
That
terms
is
of
always
settlement.
open.
Prayer of the petitioner
No, that might have
for one-time settlement of the loan amount was pending consideration. Stop. Today, learned advocate representing the bank submits that the said proposal has been rejected by passing order on 23rd July 2025. Stop. Paragraph. The petitioner still intends to enter into a settlement with the bank. Stop. Accommodation has been sought for. Stop. Hearing of the writ petition stands adjourned till 12th August.
Lordship will kindly not grant that longer date. I will tell you or indicate, Lordship, why. Because this matter,
I can
Lordship,
come back sooner. I don't have a problem.
May I? Lordship, this matter, Lordship, we had to approach this Honorable High Court, obtain an order under Section 14, like a Lordship's grants us, because the District Magistrate was not disposing of this application for a very long time. We have obtained that order. Thereafter, before the Honorable Debts Recovery Tribunal, this matter has consumed the tribunal's time for more than a year and a half. They have not approached, Lordship, with any concrete settlement. Today, Lordship, this cannot be used
I have
as a
been
ploy
getting settlements from there is no
just
ploy.
one postpone this.
Thing is, I am not passing any
Lordship will
interim
kindly-
order.
Lordship, I understand, but Lordship knows how it is, Lordship, that they will show the pendency of this writ petition
When is my
as
next
the
date?
ground that
The next
the
date
order is not
28th of August in Debt Recovery
executed.
Tribunal. Where will I show?
No, no,
The
it is
bank
not
is interested in taking the money or unnecessarily harassing
We
the
are
petitioner.
interested in proceeding,
Then I'm saying I
executing
want
the
to
order of
settle.
the Section 14 court.
Next date is
District Magistrate.
28th of August. Where will I show this order?
Because the bank
make
is making
sufficient-
6th of August.
Yes, yes, not a problem.
6th of August.
Some
Yes.
of that.
No, the affidavit of service.
Yes.
I beg to appear for the respondent number 1 to 4, bank.
Number 13 and
Number 5.
Do you appear for the bank in the original side matters also? There was another matter in the morning. Nobody appeared for the Punjab National Bank, and I couldn't see anybody. So I don't know. I have directed for further service. Check up.
I'll check it up.
My lord, the affidavit of service. My lord, in this writ petition, the crux of the issue is that the managing committee of a school had selected two people to function as the joint signatories of 7 bank accounts held in the Hura branch of Punjab National Bank. These accounts are all related to the school. School expenses are managed and administered through these 7 bank accounts. Now, my lord, before there is a pending litigation before Honorable Justice Parthasarathi Chatterjee. That litigation pertains to a disturbance being caused at the behest of private respondents, whereby they are continuously interfering into the administration of the school.
Who are they?
The private respondents herein, they are members of the society who had set up the school initially. Now they are interfering into the daily functioning of the school. They are holding spurious meetings. They have tried to constitute new managing committees, and all these disturbances were being caused. In this factual conspectus, a writ petition had been filed so that appropriate directions can be passed upon the board or the school service commission, and as well as the BDO, to refrain from interfering and to allow the headmaster to rejoin his duties. This writ petition is currently pending. In the midst thereof, what has happened, the bank signatories have been changed. 2 people from the society have now been incorporated as bank signatories.
At whose instance has
At the
this
instance
been
of the
changed?
society.
at the instance of these members of the society, bank account signatories have been changed. Our grievance is that if the bank signatories are changed unilaterally, who by persons who are not members of the managing committee, first of all, my lord, the PAN card of the bank account to which these bank accounts are linked, that though that PAN card has been issued in the name of the school, we hold the PAN card in our possession. So all these factual circumstances are there, and we had also given prior notice to the bank authorities.
What do you want?
I
in this
want
writ
reversion
petition?
of the bank signatory to the original signatories who are members of the managing committee, namely the headmaster and the secretary of the managing committee. But my lord, we seek an interim direction for disbursement of salary of the teachers. 31st May 2025, a salary sheet had been submitted before the concerned bank that you are required to sanction, we are required to disburse this amount for on account of paying the salaries of the teachers. That salary sheet is at page 83. I had written a letter to the bank stating that there might be an attempt to change bank signatories because of the pending skirmish between this managing committee and members of the society. That was given on 4th of July 2024. Thereafter, again this year on 5th of May 2025, I had again addressed a communication stating that you please be aware that there will be persons coming to you requesting change of bank signatories because they want financial control over our institution.
What will the writ court do over here?
My lord, pass directions upon the bank so that the signatories can be reverted. That is the sole grievance in this writ petition.
May I just intervene, my lord? This is, my lord, the clash between the two managing committee. Now, my lord, what has happened? We have received a resolution, my lord, regarding the change of managing committee. Bank has acted in terms of that resolution. Now, my lord, the signatory has been changed. Now, what is this gentleman has done, my lord? He has make a complaint in the hotline. So the account, there is some discrepancy in the account. You kindly freeze the accounts. Now, my lord, after filing of this writ petition, they are praying before your lordship, my lord, to disburse the money.
Yes, I had raised this dispute because there is discrepancy. I am not, my checks are not being cleared by the bank.
Till, my lord, we have nothing to do. Till that, my lord, the coordinator bench has not decided the
yes, it is
main
pending.
issue.
It is pending. We have
We have
mentioned
to,
the
my lord,
matter.
give the opportunity to the new managing committee in terms of the Banking Regulation Act. My lord, we have to allow them to opening the account. We are kindly, my lord, consider the resolution we have received.
Who is appearing for the private respondents? Has it been
But I am
served?
appearing for the private respondent number 13 and 14, my lord.
13 and 14.
That
Society.
is a society. Yes, my lord. My lord, the gentleman who has come up before this court, my lord, seeking that the account should be defreezed. This gentleman is no longer the secretary of the managing committee.
Yes,
that is point number one, my lord. That is my first submission. My lord, the second submission is that why he has been removed from his post because of this malpractice. He has been engaged in all sorts of illegal activities.
All right, well, 1 minute. Don't get excited. Thing is, there are some teachers in the school.
Yes, my lord.
Yes.
We have.
Are they getting their
because
pay?
No, my lord.
Are they getting their pay?
Yes, my lord.
They are being paid.
They are being paid because
it is not that the teachers are.
It is not that
serving without payment.
No, my lord. So far, I have got the instructions. Milord, let me.
Two accounts has been unfetched.
Milord, kindly bear me for a minute.
Then I'm not hearing.
Milord, kindly bear me for a minute because some of the members of the managing committee are the ex officio members of the society, and this is the reason that it is within our knowledge. From the cash, we have disbursed this.
My lord, this managing committee.
Everybody is getting paid.
My lord, this managing committee, which my lord, maybe in the interim they have released some amount to the teachers.
So
That's
my
my
lord,
lord, by the private respondent.
My lord, but the day to day,
kindly consider this later.
My lord, but day to day school administration is being jeopardized.
No,
We are not being able to access the funds. My lord, this managing committee was duly constituted upon submission of MC4 form before the district inspector.
A bank account in the Punjab National Bank. Paragraph, it appears that there are private disputes in between the petitioner and the private respondents. The writ court will not be the competent forum to decide as to who will be the appropriate person to operate the bank account. There are several disputed questions of facts raised. In view of the above, no relief can be granted to the petitioners in the instant writ petition. The writ petition fails and is hereby dismissed. Stop. It will be open for the petitioners to approach the competent forum for adjudication of the disputes in accordance with law if so advised. Service taken on record.
My lord, may I make my lord, may I make one last submission? That submission is they are bound by certain master directions issued by the RBI. What they should do before changing the what they should do before changing the signatories. My lord, how did they verify the PAN details? The PAN card lies with me. I am the managing committee duly constituted.
Yes, yes. Next. Next.
Grateful, my lord.
Yes.
Is my application.
I appear on behalf of the respondent number 5, GEM portal.
My lord, may I just
For
give
the
you lordship?
Respondent Union of India, my lord, the application was received by the office of the Medical Director, Southeastern Railways office on 22nd July. My lord, on behalf of the Union of India, we have not received any written instructions as of now. I have received the brief yesterday
Let
evening.
me
May I
just
just give you
listen.
lordship a
My
brief
lord.
overview?
What exactly
My lord.
is the nature of instruction you would require?
Yes, ma'am. May I just indicate to your lordship the brief overview of the matter? My lord, the petitioner supplies cooked diet to my lord government hospitals, healthcare kitchen and dietary services. Initially, my lord, the petitioner, this quality caterers, was a proprietorship firm. Accordingly, registration was obtained with the GEM portal as a proprietorship firm. Thereafter, my lord, this proprietorship firm was converted into a partnership firm. Accordingly, my lord, necessary documents were uploaded. What happened in the meantime, my lord, a tender was floated by my lord the railways for this railway hospital. While submitting the documents for this participating in the tender, all the documents pertaining to the partnership firm were submitted. But my lord, since it was done through GEM portal, the registration number which was allotted to the proprietorship firm that was used, and accordingly, my lord, it is tagged to the earlier PAN and my lord, the earlier my lord GSTIN number. There's the GST registration number. My lord, contract was awarded to the petitioner. Petitioner supplied rendered the service of healthcare kitchen and dietary service since October 2024. When we raised the bills, they say, well, they took legal opinion from the department. I mean to say the railway hospital. They say that unless and until you submit the bills with reference to the PAN number of the proprietorship firm and the GSTIN of the proprietorship firm, I am not going to release the bills. Well, today, well, for last about 8 or 9 months, we are.
What can be the possible way as to
what we have done,
resolution?
we have also raised a ticket with the GEM portal. Well, that is the way of registering funds. That ticket was raised in the month of April 2025.
All right.
So, Malad, that ticket is pending consideration by the GEM portal. But what I am facing, Malad, there are Malad within
Payments to be made which you cannot make. I can understand. How can it
So
be
far
resolved?
as GEM portal is concerned, GEM portal has already, my lord, provided a response to their ticket. That is on 25th of April, my lord, they have raised the query. On 2nd of May 2025, my lord, we have uploaded the response. I'm giving serving a copy. This is the copy. And my lord, before my lord, coming to my lord, the response, my lord, kindly.
What does this say?
My lord, before coming to this response, my lord, kindly comes to page 72 of the writ application. 72.
Okay.
Work order. Yes.
Yes.
My lord, what has happened? There was, my lord, one proprietorship firm, sole proprietorship firm. Then there was, my lord, partnership. Now, my lord, when they have participated in the new tender, my lord, kindly sees in page 72, they are quoting, my lord, they have quoted the old GST number. That is, my lord, appearing at page 72. Kindly comes to the, my lord, 1, 2, 3rd, 4th column. GST, the service provided details, GST, and your lordship would kindly appreciate. We are not the one who can, my lord, correct the information which will be, my lord, provided by the, my lord, seller or the buyer. Anyone.
Followed that
Lord,
there is
just
a
to
problem
interfere,
with
my
regard to partnership and proprietorship. How it can be resolved? Please let.
My lord kindly takes up page 168 for once, then comes back to my learned friend's document. 168 kindly takes up for once. Situation will get very much clarified here and why the trouble has been created.
Is somebody opposing the partner or something?
No.
No, my lord, they had participated in the bid floated by the railways by quoting a GSTIN number which was suspended way back on 6 December 2023. How could they do that? Because by the time they had already obtained a new number, but they had not furnished that. Kindly seize 168 for once. Then I will take back your lordship to the list of dates.
168, 27th June. Is
Kindly,
it
my lord,
mentioned?
kindly, my lord, read that with 174, my lord, which will, my lord, show that that was not suspended.
Yes, that's I am absolutely on that one.
The bidding process started in August. GSTN had already been suspended in December 2023. Law Department participating is not legally permissible. 168. And now is?
Now lordship kindly comes back to the list of the dates in the first page of the writ application, the second page, list of the dates, short list of dates.
Yes.
Kindly sees what the petitioner says. 25th April 2023, the newly formed partnership firm Quality Caterer obtained a new GST registration bearing number so and so. Well, this number they do not furnish when opting for the bid. They place the number which had been suspended on 6 December 2023. That therefore this is the reason for which now they are coming up with bills.
How can this be rectified?
Just indicate, my lord, my learned friend has made his
Way of rectification. There is some problem.
When we uploaded the documents, let them produce the documents. We uploaded the GSTIN certificate of the partnership firm. Let my learned friend produce the records of the case, and I will demonstrate from the records of the case that I submitted the GSTIN certificate of the firm, not the proprietorship concern.
Page 72.
Well, I will produce each and every document. Kindly ask them to
1
produce
minute.
the documents from the records.
Page 72 is the contract.
Yes, absolutely, my lord.
Where is the GSTI number?
My lord, kindly comes to the 1, 2, 3, 4, first column, my lord, service provider details.
Yes, service GSTN.
GSTI, my lord. But that's the, my lord, full GST number with respect to the, my lord, sole proprietorship.
They just indicate, since, my lord, the registration number of the GEM portal, which is tagged with the earlier GSTN number, whenever a contract is being awarded to me, the earlier GSTN
automatically it goes
auto-populated. It gets auto-populated. Absolutely, my lord. Because it is tagged. Just like, my lord, our Aadhaar is tagged with our PAN. It is tagged. So whenever I'm quoting that number, this is what is happening.
On this, my lord, I have to, my lord, take, my lord, specific instruction. Or this is the same question, my lord, I put to the authority.
That is certainly.
I put to the authority that whether whether under a single ID they can have two different GST number or not. To which, my lord, they have said, my lord, they have to check with their backend team, and they will request some time, 3 or 4 days, at least 3 to 5 days time.
Kindly take page 171 for once. 171.
Yes.
Well, this is the seller profile maintained with the GEM portal. This is government e-marketplace.
This is your new one, partnership.
Your lordship will find I have uploaded the new GSTIN number, validate GSTIN, because it is earlier one is being referred to. And my learned friend, perhaps railways have not instructed my learned friend properly. I submitted the GST certificate of the firm, not of the concern, proprietorship concern.
Check up. Both parties, please check up how it can be resolved. Because page 71
is approaching, my lord. Kindly visualize, my lord, my predicament. Puja is approaching.
Yes,
I have to
certainly.
pay my workers.
Certainly. How it has to be resolved. Please come. The petitioner performed certain work in terms of the contract.
We are still
issued.
performing. We are still performing.
Achha, the petitioner is performing certain work in terms of the contract issued by the railways. Stop. The petitioner, however, is not being paid, allegedly because the GSTIN number is not correctly mentioned. Stop. The petitioner, the GST registration number of the petitioner's firm is a list of dates. May I take your
lordship's kind?
Yes, yes. It will 19AA. The authority are referring to the earlier number of the petitioner's proprietorship firm, which stood suspended in December 2023. Stop. Because of non-payment of the dues, the petitioners are not in a position to pay its employees. Stop. Next. Learned advocate representing the respondent authorities are directed to revert with positive instruction with regard to the mode and manner of resolution of the dispute that has cropped up. Stop. The formalities to be complied by the petitioner for resolving the dispute so that payment can be made in favor of the petitioner shall be made known on the adjourned date. Next Friday? First.
Instead of next Friday, any other date.
Any other date? 5th of August? 5th August, service is taken on record.
Yes.
The subject matter of challenge is an order which was passed by the Enemy Properties Authority in terms of an order at page 149.
Yes.
Now, I find in this order that there was, my claims were taken into consideration vis-a-vis the claims of the authorities had been considered. Then the operative portion, I made a mistake, I should, I tender my unqualified apology. One very important deed. This inadvertently my learned
missed.
Could not
All right,
yes,
copy.
have the copy.
Yes, just now I have been served. Copy.
Just now? All right.
To cut the matter, subject to one of my learned senior friend permits me. This is an application, writ petition has been filed challenging the order passed under section 18 of the Enemies Properties Act 1968 as amended. There is no provisions to file a writ petition because there is a statutory, there is an alternative forum. Forum is High Court under section 18C. So, my lord, the writ petitioner has to file an appeal to the High Court under section 18C of this Act.
Similar orders
Yes, similar orders have been passed by the coordinate benches of this one.
Let me see.
There are many orders. This is judgment and order delivered by the London Single Judge.
18C.
18C. If any person claiming that that his property has been vested wrongfully and agreed with an order passed under section 18, then remedies, the statutory remedies under section 18.
Your Lordship will kindly consider that so far as my client is concerned, he had initially filed an application under section 18 of the Enemy Property Act in respect of a landed property.
But this is the Allahabad High Court's order also.
Landed property to group 1
And moreover, this is a landed property. If it is claiming, then it comes under group 1, not under group 9.
No, that is different. In that case, it is.
I'm not taking that, it's not pressing on, but on merit will not.
It is 226. If you say group 1, then it will be 226. It will not be 18C.
No, but I am pressing 18C. So maintainability of the petition at the threshold matter, this is my first.
The order of central government 18 may prefer within 60 days from the date of communication, file an appeal to the High Court. Law.
On the same issue, the order under section 18 has been challenged.
By filing a writ petition, point of maintainability we have raised, and the Honorable Court passed this order, directing the liberty was given to the petitioner to file an appeal or converted the writ petitions to be an appeal.
Yes, that can be done.
That can be done also.
এটা তো ফরম্যাট আলাদা আছে
format
কি করে
আগে
কনভার্ট হবে
করেছিল আগে করেছিল
না তারপরে আমরা বলেছিলাম আপনি নতুনই লিবার্টি দিন
It is up to them. FMAT.
So 60 days is a time limit, so it is well within time also. So this can be converted to an 18C appeal. All right, first appeal, please come. But
Then Milord, it must go before a.
it is taken as a civil appeal.
division bench.
Then
Division bench for admission.
division bench, it has to be admitted. First appeal, admitted, and then it has to be taken up.
fresh
But
And the grounds of the writ will be the grounds over there.
Or alternatively, they can withdraw or file afresh in a proper format of FMAT.
Yes, that you can think of, because
এই 30 দিন সেকশন 14 লিমিটেশন ওকে দেওয়া
Milord, on instructions, I am submitting that they are going to take possession.
what can be done? Because if this bench, when are you taking possession?
But it is in the process of the permit.
I can immediately direct.
Just yes, give me a breathing time, I can file it.
No, I'll convert this, permit you to convert
Yes,
this.
yes, I
Then
can.
you can, no requirement of withdrawing. You can immediately take steps. Acha, please come. Within 1 or 2 days, nothing is going to happen.
Yes, nothing will be happening.
Ah. Acha, the petitioner is aggrieved by the order dated 26th June 2025. Passed by the Joint Secretary to the Government of India under the Enemy Property Act, 1968. Stop. Learned advocate representing the Union of India draws attention of the court to section 18 caps C of the Act, which mentions that any person aggrieved by an order of the central government under section 18 of the Act, within a period of 60 days from the date of communication or receipt of the order, file an appeal to the High Court on any question of fact or law arising out of such orders, and upon such appeal, the High Court may, after hearing the parties, pass such orders thereon as it thinks proper. Stop. Next. The instant writ petition has been filed within the prescribed, within the statutory time period. Stop. As the writ petition per se will not be maintainable, the department is directed to convert the writ petition to a regular first appeal to be decided by the High Court. Stop. It will be open for the petitioner to take necessary steps for hearing the appeal.
Only one thing in
Affidavit of service filed in court is taken on record, and the supplementary affidavit filed on behalf of the petitioner in court today.
Milord, paragraph, kindly, Milord, for a second, kindly, paragraph 36. This is, Milord, at the request of my learned junior, Milord.
Yes, which page is it?
Page 36. This is paragraph 36. I'm sorry.
Page number.
Paragraph 36, I'm sorry.
Page 27. Yes, what is there?
Milord, he may be dispossessed.
See, 60 days is the appeal time. How can it be dispossessed prior to that?
The entire period is open now. So
yes, you have 60 days time. Till August, you have 60 days time for appeal. How can the authority take steps?
Already in another cases, they have already taken.
No, it is absurd. Absurd thing. Other cases cannot be placed in.
Undertaking they will not give here.
No, we will not give it now. Since the writ petition is not maintainable.
Give some breathing in the middle.
Let the
Right.
writ petition be
It is pending. It is not that your writ is being dismissed. It is merely converted.
Yes.
So your writ is there. Today is Friday. Immediately you take steps. The authority
2-3 days, nothing will happen.
can never take steps, ought not to take steps. I won't say never.
Appeal period is.
The appeal period has to be given. Otherwise, how can it be? And if they take,
I do not exhaust my time.
yes,
And then they take a step.
then it is something different.
This is then acting fast and loose.
Then
In
this
other
cannot
matters,
be done.
facts are different. After expiry of the limitation period, they will proceed.
All right.
I'm grateful.
I do not require these order copies. You can take these back. এটা কনভার্ট হয়ে গেল এবার রিট পিটিশনটা কিছু ট্রিটেড টু বি অ্যাজ ডিসপোজ কিনা সেটা একটু ডিপার্টমেন্টে কথা বলবেন কনভার্টেড টু এ রেগুলার ফার্স্ট
সুবিধা মতো দেখি।
numbered. Yes.
Take.
Yes.
Sir, I'm grateful to Mr. Nondi Miller.
No, sir.
I should be granted a liberty so that I can file a memorandum of appeal. Otherwise,
I was inquiring because the grounds are already here. Maybe a formal, these grounds can be set out in the memorandum of appeal and it can be done.
Yes, therefore, a memorandum of appeal along with this application,
This will be as a
application
stay.
will be treated as a
Stay application
yes,
and then
yes.
you come, whatever is required to be done. Is it required that it has to be recorded? It will be open for the petitioner litigant to file a proper memorandum of appeal.
Yes.
Acha. Memorandum of appeal for proceeding with the first appeal. Our act line, learned advocate on record with the petitioner apprehends that the authority will take steps to dispossess the petitioner immediately.
I'm grateful.
Paragraph. It is expected that the authority will wait till the period to prefer an appeal is exhausted prior to taking any coercive steps in the matter.
Grateful, ma'am.
Which is
Grateful. I am taking a breath for some time. Grateful.
My application, this has been assigned before your lordship. So this writ application is for asserting my fundamental rights under Article 19(1)(g), also bordering on 21, and the complete apathy shown by the police authorities in respect of this, what is going on. Lord, I'll tell you, lordship, needn't be troubled with the papers right now. Lord, I am in the process of constructing and initiating a factory for manufacture of DI pipes in Kharagpur. I have all valid licenses. Most importantly, my lord, I have a consent to operate from the Pollution Control Board. I have all the licenses under the Pollution Control from the Pollution Control Authority. Lord, the local.
What is this Kharagpur Janojagaran?
Lordship, I am appearing for the private respondent number 8.
Which has
9 also?
Yes, my lord. The
10
other
also?
private respondents are all members of the committee.
This committee, they try and get a group of about 100 people, and I'll show the picture. When my laborers go to enter or officials want to enter, they pelt stones. They're attacking them with rods. Now they've put a banner. They've put roadblocks. They've put stones and boulders.
What are you trying to do? Make construction?
To run a factory. So much for Bengal
Is it
trying
your
to become my land, my factory, all licenses, everything I've annexed. And police has done nothing about it.
All right.
All I want is police to ensure that this demonstration, these are not my workers, not my employees. Employees are workmen, they can have a right to strike or demonstration. That's preserved under Article 19 because the Trade Union Act gives them that right. Here, these are complete strangers.
All right, let me hear.
I just indicate what I seek. I beseech your lordship to direct the police to give me police protection at my cost so that I can enter my own factory. And when I do that, they will ensure that no stones are pelted and people are not attacked with rods. Specific complaints. From February, I have not been able to enter my own factory. What is the ground? that if the factory
Is it demarcated?
Yes, yes.
There
they're
is a gate.
bounded.
There is a
I'll show the picture. Manoj, kindly have a look at what is happening here. And this I'm addressing as an officer of the court. Kindly have a look at the date. How does the police or the state allow this? This is my factory premises, and this banner is by people who my learned friend is representing, and there are boulders. And when people go, they get attacked. My laborers are not willing to go in. I want police protection so I can go.
All right, let me
Who
hear.
is this Jaguron Andolan committee?
Let me hear.
As a state, I am in a bit of precarious situation.
Why?
First of all, as a holder of industry, they have to be given an opportunity to perform their functions, their businesses peacefully. That is the primary object the state has to ensure. But, my lord, I also have to ensure the safety and security of the citizens. Of the
safety.
Yes,
What's the
why
safety
safety?
issue?
Yes, where is the safety issue of the local people? Where this Jano Jagaron Moncho or something comes in is they have an apprehension that the lands inside the factory premises are being filled up by some dry ash.
All right.
There are pollution issues. There are health hazard issues, which are in their apprehension. I am not going into the merits whether they are baseless or absolutely
Have you ascertained whether the
as a
petitioner
police
no whether the petitioner has all licenses?
as of now
or...
as a police authority, we cannot have or exercise that jurisdiction.
No, just see whether the petitioner has papers.
Yes, my lord, that if your lordship directs us, we will do it. But as of now, the situation is such that they have an apprehension, rightly, wrongly, whatever may be. They have an apprehension. They are showing, I do not agree to what Mr. Banerjee
Is it
says.
a water body or something?
No,
It
no.
has to be filled up, nothing.
There are low-lying lands inside the factory premises.
All right.
But I do not agree to what Mr. Banerjee says that there are pelting stones of whatever. They are sitting in dharnas, demonstrations, peaceful protests. As far as my instruction goes, there are demonstrations outside the factory premises, not within the factory premises. And
gate is blocked. How can
that
this is what the photograph that has been shown.
Yes, I understand.
The gate is blocked.
Gate is blocked by a placard.
Yes.
By a placard that they can remove. But
the moment they go to remove,
yes,
there will be
again
riot.
That
we will use the right word. I'm shocked. This is the stand of the state.
1 minute.
I am not saying. I am not taking sides.
What is the way out?
In my humble submission, first of all, they should have, before approaching your lordship, should have approached a civil forum.
For what?
For at least having access, proper access to their, if they find that there has been some sort of disruption. In
that case, nobody will be able to enter his or her own land because somebody else will go and stand there.
I understand. But my lord, at the highest will, subject to what your lordship will, direct us to maintain a vigil and maintain the peace and tranquility of the area.
Just
will
wait.
that.
Yes.
Let me hear. What is
My
your
lord,
trouble?
The fictitious acts of vandalism that have been ascribed to the members of the
Very well, I take it fictitious.
They are
Do not
absolutely
disturb, let them go and do their
But we are not disturbing. And
All
one
right.
other thing, my lord.
Yes.
These are not miscreants or hired goons. This is an informal social welfare organization which is headed by a 69-year-old gentleman.
All right.
There have been absolutely no cases of stone pelting, no nothing.
Very well.
One other limited point, my lord. It is not today. Kindly have a look at the prayers in the writ petition.
I am not looking at it. You do not disturb, let them
There
do
is
their
no
work.
disturbance, my
Very
lord.
well, I'll
All that
record.
it's doing is also my fundamental right.
Yes.
I have spent, this committee has spent several months in researching, and it has data to show that these factories are in fact causing pollution.
What
Now,
factory? Nothing is
there's
there.
a
It's a
my lord,
vacant
kind
land.
please, no, they have set up, or rather they are claiming that they have permission to set up a factory which will interfere with the groundwater of the area.
So people will hold me to ransom.
1 minute.
Nobody is
Okay,
holding
please
my
wait.
learned friend's client to
Please wait.
ransom. Rashmi Metallics is a
Please wait.
several thousand crore turnover organization.
Placard there, ma'am.
That is not my placard.
Yes.
It is a seriously disputed. Anybody could have, with utmost respect, my
Let-
lord, anybody could have printed this flex and put it up.
Let the construction or whatever is going
I have,
can't let it
my
be
lord, on
constructed.
instruction I submit, there has been nothing there except
right.
in exercise of my fundamental right, peaceful demonstrations against a company which is possibly flouting environmental norms. That is my fundamental right as a
Right.
citizen of the country.
So you go and you proceed before the appropriate forum to obtain orders
Absolutely.
to stop them
Absolutely,
from
absolutely.
running the factory over there.
I have extensive
then-
data to do that. My instructions are that a public interest litigation
Yes,
will be
please.
instituted.
Please.
But my lord, these are, and also just one minor technicality, my lord. I do not find, subject to correction by my learned friend, any pleading that on the Kharagpur Thana OC not taking a complaint, the provisions of 156(3) CRPC were resorted to. There nothing, 175 of the BNSS now, nothing. So from February, a multi-crore corporate entity has been sitting tight with a closed factory. Now in July, they come up without exploring the opportunity of 175 BNSS and they say direct the state authorities to open the lock.
All right.
I have not placed the lock, my lord.
Could
I have not done anything.
No, they'll go. It's their land. They'll make.
Yes,
their-
absolutely.
Could I just respond to this in 1 minute? Not similar
No,
issue had
please
come
do
up
not.
for this honorable court. Just for the sake of brevity, Lord, kindly have a look at the directions that were passed. Please. Kindly turns over, my lord. This is what I seek from your lordship today. Page 3, last paragraph. This was with regard to, I had only run the matter, this was with regard to, my name will not be there, Dalhousie Institute Club. Employees were making a situation where members and other board members could not get into the club. This was taken up, page 3 at the bottom.
No, we'll not go into all these things.
Very
Please
well.
come.
May I just enter my own land and do what I'm
Yes, yes.
supposed to? Police will give me the necessary protection.
With utmost respect, I have never prevented.
All
What
right.
veracity is there that this placard has not been put up by them?
The
Then I'll remove it if it's not.
I am an ordinary citizen of Kharagpur, not a goon.
Petitioners allege that
Behaving like-
the private respondents are preventing the petitioners from entering into their own land for raising construction in accordance with the permissions/licenses issued by the competent authorities. Stop. The aforesaid contention of the petitioners is denied by the learned advocate representing the respondent numbers 8 to 17. Has Wakalatnama been filed?
Yes, my lord. I am told that some of the individual private respondents have not received a copy, but my instructions come from the committee. They are representing because all of them are members, my lord.
All right.
So I filed it.
All right. Denies the allegation of the petitioner. Stop. It has been submitted that the private respondents are peacefully raising their grievance against the activities which are sought to be done by the petitioner in setting up a business at the said plot.
Factory.
At a business, na factory. Yes. Factory at the said plot, which will cause pollution in the area. Achha, pollution by way of depleting the groundwater level in the area.
And also deteriorating the quality of groundwater, my lord.
And also deteriorating the quality of the groundwater in the area. Paragraph. Next. The learned advocate representing the state respondents submits that the police will certainly take steps if any event of violence or breach of peace is noted. Stop paragraph.
Kindly only records that we deny the allegations of.
It has been denied. The allegation made by the petitioners is denied by the state respondents. Stop. Next. Be that as it may, as it appears that the private respondents denying any involvement in preventing the petitioners from entering into or making any construction over the subject land. Accordingly, the instant writ petition is disposed of by observing that it will be open for the petitioners to enter into their land for raising construction strictly in accordance with the plan sanctioned / permissions granted by the competent authorities. Stuff. In the event the petitioners face any resistance at the hands of any of the private respondents, comma, it will be open for the petitioners to approach the police authority who will provide necessary help to the petitioners.
Including police protection, necessary help, including police protection. Otherwise, I'll not be able to enter again.
Including police protection.
There's only one thing, your lordships was.
As the writ petition is being disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
My lord.
Could I make one? Could I prefer one indulgence? That now that the police is saying that it'll do whatever, then Kyrie directs them to ensure that there is no breach of peace when I'm trying to have egress and ingress.
Separate provisions under the procedure code are
Shall
there.
ensure that there is no breach of peace in the locale.
Was desiring that we may have the liberty to go through the permission papers if required.
Absolutely.
That may
Jagrut committee is
indicate.
there.
Now, since they say they do not
not doing
object,
it.
why will you enter into all these
Pollution
things?
control board
We have
certificate.
received
From
these
February, they've not
apprehensions
done
from local
anything.
people.
They are out. Now somebody else may come in and say it's something else. Then
At
we'll
least
see.
we have the liberty to go through.
No,
Pollution
you
control
will
board
be
certificate.
supporting them.
They will
Yes,
never
we have
support
to.
me, not this
We have
69-year gentleman, whoever he is, however nice he may be.
Definitely, we will not
But
support
from
them.
February
Somebody
to
has
the
to look
factory
after the
they called
ecological
a petition to
welfare.
ransom. The
You
affidavit
can always move.
Yes, yes, my lord. I have advised my clients. Yes.
Thank you. We'll file the case.
Do not resort to violence. Do
My
anything.
lord, no, but these are local
I have
citizens.
rules kept in front of me.
Most very well.
Grateful.
Yes. One Passover matter is there. Yes. Is your other side here?
Yes, but we have served.
Yes, Mr. Shah. What is it?
I tell your lordship, my lord, I am a developer promoter. I have carried out construction.
Private respondent has been served.
For this they feel the service, my lord. I have given notice upon the other side also prior to mention for upgradation also.
All right.
Both by email as well as by post.
All right.
Lordship, a short
Supplementary
question.
affidavit. What is a supplementary?
Supplementary is, my lord, execution proceeding has been initiated after the filing of the writ petition.
Madam.
What is it?
My lord, I tell you lordship what has happened. My lord, the entire project was completed in 2013 and the completion certificate which has been annexed and which is at page, lordship may kindly come to page 49, is of 2013. The entire project was completed in the year 2013 April. Lordship kindly comes to page 49 once.
Yes. Yes.
This is the complete. Therefore, the entire project stands completed by 2013. My lord, the private respondent has initiated a proceeding under the 2016 Act. 2016 Act, that is the Real Estate Regulation and Development Act 2016. My lord, my humble submission, which is that the Act of 2016 is not attracted in cases of construction which has been completed before 2016 Act has come into place.
No retrospective operation.
No retrospective operation, and which is settled by the Honorable Supreme Court because this issue is no more res integra. This has been settled by the Honorable Supreme Court. They lodge a complaint before the concerned authority in respect of my construction because their allotment was cancelled. Now they have made a complaint against me. I took the very first point that the application itself is not maintainable and the jurisdiction does not have is vested with the said authority. Therefore, the authority lacks jurisdiction to carry out further proceeding in the said proceeding.
Tell me one thing. Page 49 is a completion certificate issued by the Gram Panchayat
Yes, because
for the G+7-story construction.
Yes, I have carried out the construction in respect of a sanction plan issued by this competent authority.
Competent authority, Panchayat is not the competent authority to sanction G+7-story structure.
But Lordship, I have done along as per the sanction.
Absolutely wrong. It could not have been done. Who is the authority?
The sanction plan ki issue kore.
How can the completion certificate be issued by the Panchayat?
Well, we have annexed some completion certificate with that we have received, Lordship. Whatever is there on record, I have shown to your lordship.
Yes, I understand then.
Now, lordship, they made a complaint in the year 2018. After that, after the act has come into place, after the issuance of the completion certificate, we have taken the specific point that the authority concerned does not have the jurisdiction to carry out, my lord, the proceeding against us. The authority concerned, overlooking such point of maintainability, overlooking such objection, has passed an order against us, wherein, my lord, the authority concerned has directed 18 lakhs to be refunded to the authority to the other
Which
side.
authority?
My lord, the authority, that is the first authority, which is the order is at page, lordship kindly comes to the page
RERA.
16.
RERA.
Yes, RERA. West Bengal Real Estate Authority. Now, prior to that, lordship kindly come to my written objection, which is at page kindly comes to page 97 once. This is my written objection, and the specific point taken is at page 98. Point number 6. May I just place it, my lord? That the complaint is not maintainable before the regulatory authority, and as such, the said complaint is to be rejected on this ground alone, that the Real Estate Regulation and Development Act 2016 was enacted in the year 2016 with effect from 25 March 2016 and is retroactive in nature as held in the judgment of Messrs. New Tech Promoters and Developers Private Limited versus State of UP. Therefore, the complaints which...
What does radioactive mean?
Not radioactive, it should be retroactive. Retroactive. Retroactive means in respect of the, the projects which are going on. It is not radioactive, it is retroactive. Therefore, the complaints which relates with the ongoing projects which are registered with RERA after enactment of this act can be filed before the regulatory authority. However, in this, the project was completed in the year 2013 and completion certificate was also issued by the Gram Panchayat on 8 April 2013. And as such, the instant complaint is not maintainable before this regulatory authority. Now, the regulatory authority, while passing the order, says that you have not raised this point, although we on record, I have shown to your lordship that I have raised this point. The regulatory authority, while deciding, says that you have not raised this point and you have not raised this point at the very first instance, though it is on record. I will show to your lordship the order of the first authority. And the first authority passes the order wherein the first authority directs me to pay back rupees 18 lakhs to the private respondent. Challenging that, I preferred an appeal before the appellate authority. Again, taking the preliminary point that the proceedings are not maintainable and the proceeding be quashed as the authority concerned does not have the authority to, my lord, to look into it and to decide the issue. Now, lordship kindly comes to page 116 once. This is the order of the first authority. Now, lordship kindly sees the reasons which are at page 117. Point number A in the middle portion at page 117. Three reasons have been assigned. The first reason, the point of maintainability should have been agitated by the respondent on the first date of hearing when respondent was present. As per the legal provisions and conventions, the maintainability point cannot be taken after the first hearing in which respondent appeared. In my humble submission, my lord, I say that it's a legal point which can be raised at any point of time. And moreover, in my written objection, I have quoted that point, I have taken that point, which has not been considered by the first authority. And lordship, this point has been settled by the Honorable Supreme Court. I shall show to your lordship the decision.
You have the act over here?
Yes, my lord, I have the act.
What is the, who are the members? Let me see the constitution of the authority.
Before that, I will show to your lordship section 3, which is the applicability part of the act. Section 3 says, my lord, section 3. No promoter shall advertise, market, book, sell, or offer for sale, or invite persons to purchase in any manner any plot, apartment, or building, as the case may be, in any real estate project or part of it in any planning area without registering the real estate project with the Real Estate Regulatory Authority established under this Act. Provided that projects that are ongoing on the date of commencement of this Act and for which the completion certificate has not been issued, the promoter shall make an application to the authority for registration of the said project within a period of 3 months from the date of commencement of this act. Therefore, the project must be ongoing. Then only the project will come within the ambit of this act. My project is a completed project which has been completed in the year 2013, as is demonstrated from the completion certificate issued by the authority concerned. Now, Lordship kindly sees
who is the complainant?
Complainant is the private respondent. Complainant's case is that, my lord, there was a dispute between the complainant and my client.
Yes.
As per my version, the complainant didn't pay the entire amount.
All right.
As per the agreement, if he doesn't pay the entire amount, I will give him notice. I have given him multiple notices. In spite of that, he has not made the payment. Thereafter, upon notice, I told him to deposit the money, but he again fails to do so.
So you forfeited
So
the money.
No. I cancelled I have cancelled and terminated the agreement, and I have intimated that.
And what about the money that he deposited?
Lord, he has, my lord, chosen this forum to ventilate his grievance.
What happened to the money that he
Money is
deposited?
with me. Money is with me.
How much is it?
As per the calculation made by this forum, it comes to around rupees 18 lakh plus.
And
as
according
per
to your
my
calculation,
if I take my interest, he is not entitled to get back any money because he is liable to pay interest also as per the agreement.
All right.
So therefore, as per me, he is not entitled to get back any money.
All right. Was there any provision for forfeiture of the amount that is being
in
paid?
the agreement? There was there. It was
there.
Yes.
All right. Yes. Then.
Now, my lord, he has come to this forum ventilating his grievances. I took the basic point that this act is not coming is not against me. Now, Lordship kindly sees the order passed by the first authority.
When did you obtain the sanction?
A sanction to copy page.
Who issued the sanction plan?
Sanction plan.
Who issued the sanction plan and when was it issued?
Municipal Corporation 2008.
Well, the sanction plan was issued in 2008 by the Durgapur Municipal Corporation.
Sanction plan is issued by the Durgapur Municipal Corporation and you obtain completion certificate from the Panchayat.
They have issued the completion certificate. All right, stand corrected, Lordship. The Jila Parishad has issued the sanction, the sanction.
Panchayat could not have issued a sanction plan. If the Panchayat could not have issued a sanction plan, the Panchayat could not have issued a completion certificate either.
That has not been disputed by any of the persons over there before the
Forget a question of dispute. This is the reason I wanted to see who are the members.
Yes. The members of section 21.
My lord, page number 132 of the writ application, my lord.
Who are the members, Mr. Shahi, of this authority tribunal?
Justice Ravindranath Samanto, Honorable
that
Chairman
is the Appellate Tribunal.
of the Appellate Tribunal, my
That is
lord.
the Appellate Tribunal.
Not the Appellate Tribunal, the first tribunal, the regulatory authority.
Lordship kindly comes to page 118.
Mr. Bholanath Das, member, West Bengal Real Estate Regulatory Authority, my lord.
Lordship kindly comes to page 118.
See, the ground that the a question of jurisdiction was not taken on the first occasion, it cannot be taken up at a later stage. It's
My lord, may I allow to
very
make
preliminary.
a
This
submission
should not have
subject to a
been.
correction, my lord. May
Yes.
I allow to make my lord, as per the West Bengal Real Estate Regulation and Development Act 2016,
yes,
under section 58 subclause 1, any person aggrieved by any decision or order of the appellate tribunal, he must be aggrieved by the order of the appellate tribunal, my lord, may file an appeal to the High Court.
I am aware. Page section 58, there is a provision for filing a regular appeal. I can see that.
But petitioner is trying to avoid the appellate authority, my lord, because he has to deposit 1/3 statutory money before the appellate tribunal.
No, but then he has gone before the appellate tribunal, possibly.
Yes, I've gone before the appellate tribunal. I've
My
raised
lord,
the point of
please
jurisdiction
come,
also.
please
Appellate
come.
tribunal has not considered that
My
point.
lord,
And on the
please
contrary,
come to
appellate
the
tribunal
page-
directed me to
page
deposit the
number.
entire amount. Now, Lordship, the jurisdiction point is when it has been raised, it has to be adjudicated first.
My lord,
That
please
is the
come to the
cardinal
page
principle.
number 132, my lord.
Yes.
And it's over here, it's manifest and it's apparent that the tribunal or the authority concerned does not have the jurisdiction. And I'm supported by a decision of the Honorable Supreme Court in this regard. Honorable Supreme Court has made it very clear.
My lord, last paragraph of the page number 132. Any person aggrieved by any direction or
Lordship, may I
decision
place
or
before
order
Lordship
made by
the
the authority
decision
or
passed by
by
the Honorable
an
Supreme Court.
adjudicating officer under this act may prefer an appeal before the appellate tribunal having jurisdiction over the matter. Second page, 133 page, my lord. Third paragraph. In our considered view, the obligation cast upon the promoter of pre-deposit under section 43 subsection 5 of the Act, being a class in itself, and the promoters who are in the receipt of money which is being claimed by the home buyers / allottees for refund
I'll convert this into a regular appeal.
My lord, I have raised this point before.
Section
My lord, I have
is there.
My lord, I have already filed an appeal. I have raised this point, but the learned appellate tribunal has refused to entertain that point.
Yes.
Your lordship, in that case, directly learned tribunal to consider this point to be.
Why done by the writ
for
court, bench
admission of
order
the
passed
appeal,
by
he
a
has
court
to.
without having a jurisdiction is non-est.
Lordship, kindly indicates that. Otherwise, learned tribunal, I will show to your lordship the order passed by the
I will
learned
not
tribunal.
relegate you to the tribunal. I will convert the writ petition to a regular first appeal. You raise all points over there.
I have already preferred an appeal. Appeal is pending before the learned appellate tribunal. I have raised this point before the learned appellate tribunal. In spite of that, learned appellate tribunal is asking me to deposit the said entire amount. That is where I'm aggrieved, lordship, because the act.
1/3 amount of the entire amount, my lord.
Because my 2016 Act is not coming in, is not applicable in my case. I'm not coming on in the sweep of the 2016 Act. Lordship, may I just place before Lordship the Honorable Supreme Court's judgment in the case of
But then
Limitech?
why before the writ court and not before the first appeal court?
Because I tell you, Lordship, the reason. The reason is I'm relying upon the judgment of the Warful as well as Hardanslal, wherein it has been said that
226 jurisdiction is not ousted.
Is there if the authority concerned
Acts without jurisdiction.
If the authority concerned lacks jurisdiction, I can
Yes.
come before Lordship. There is a judgment of the Honorable Supreme Court which clearly says that if all the points are raised and one of the point is a mentality point has to be decided first before other points are adverted to. Lordship, may I show to your Lordship
No, you do not
just
have
a
to show.
one-page
These are-
judgment?
these are
Therefore,
all
this point is the preliminary point which has to be
these are all
decided first.
settled issues.
And the order has been passed by the first authority where the quorum was only of one member, whereas the law says the quorum must be of two members as per section 23.
Yes.
Lordship kindly sees section 30. Lordship kindly comes to section 21 once.
My lord, petitioner aggrieved by the first authority. Thereafter, he prefer
21 says the authority shall consist of a chairperson and not less than 2 whole-time members to be appointed by the appropriate authority. Whereas in the instant case, the order has been passed by only one member, which is at page 118. Lordship kindly comes to page 118 once.
Yes, I've seen that.
It's only signed by one member.
Right.
So the order is bad for non-quorum also, apart from the jurisdictional default.
What will be your submission with regard to the quorum of the tribunal, the regulatory authority?
My lord, please send this writ application before the appellate tribunal. There are 3 members, my lord. And if he is aggrieved by the decision of the appellate tribunal, he has a liberty to move the matter for your lordship.
Lordship, the basic order passed is incurably bad.
The petitioner is aggrieved by the order passed by the West Bengal Real Estate Regulatory Authority on 11th February 2025 in complaint number WB RERA page 116/COM 000874 Madan Kumar Chobe versus Durgapur Real Estate Private Limited. The primary ground for challenge of the order passed by the regulatory authority is that the authority did not have jurisdiction to decide the issue under the real estate, under the West Bengal Real Estate (bracket open) Regulation and Development (bracket close) Act, 2016, as the construction in question stood completed long prior to coming into effect of the subject act. Stuff. The act in question does not have any retrospective operation. Stuff. The second challenge is that the order passed by the regulatory authority was only by a single member. Stuff. There was lack of quorum in passing the order. The petitioner preferred an appeal before the appellate tribunal, but the tribunal without entering the issue of maintainability of the petition before the regulatory authority directed the appellant to file the pre-deposit amount as determined by the regulatory authority by holding the same as mandatory. Stop paragraph. The authority, the appellate authority has not decided as to whether the tribunal had jurisdiction to decide the issue or not. Next, as the petitioner raises a preliminary issue with regard to the maintainability of the application before the regulatory authority, the tribunal ought to decide the said issue first. Stop. If the tribunal, if the appellate authority is of the opinion that the application was maintainable before the regulatory authority, then the appellate authority may pass necessary order for payment of the mandatory pre-deposit. Stop paragraph. The instant writ petition is accordingly disposed of. Learned advocate representing the state respondents raises a preliminary objection with regard to the maintainability of the writ petition. Stop. It has been submitted that the petitioner ought to have preferred a regular appeal in terms of Section 58 of the Act. Stop. Next. In reply to the aforesaid, the petitioner submits that as the order passed by the regulatory authority is without jurisdiction and null and void, the jurisdiction of the court under Article 226 of the Constitution can be invoked. Stop. Section 3 of the Act has been relied upon, which mentions that the projects that are ongoing on the date of commencement of the Act and for which completion certificate has not been issued, the promoter may make an application to the authority for registration of the project. Stop. Specific contention of the petitioner is that the subject project stood completed in 2013 prior to commencement of the Act, and accordingly, the provisions of this Act cannot be made applicable in the instant case. Stuff. Paragraph. The tribunal ought to decide the issue of maintainability of the application at the very first instance prior to entering into the merits of the application. Stuff. Next. In view of the above, the instant writ petition stands disposed of.
Not only one thing, Malad, they have already levied the execution. But you kindly state the execution in the I have given my supplementary affidavit.
Execution.
Correction. Can you record it that time?
Execution, Malad, is before the West Bengal Real Estate Regulatory Authority and the authority has passed an order dated 16/7/2025. Lordship kindly comes to page 6 of the supplementary affidavit. And further direction has been issued to the district magistrate to take action for recovery of 18,14,000.
Within a month from the date of receipt of the certified copy and before the tribunal, when is it returnable? 20th of May it was returnable for calculation of the considered calculation sheet. What happened thereafter? You did not appear?
No, I appeared, Malad, before the learned tribunal. The learned tribunal, the matter was adjourned since the matter is pending before your lordship. In the meantime, the first authority has passed this order.
I have seen that. When is the next date before the tribunal?
Malad, the next date I'm told is on 4th August before the appellate tribunal.
All right. It has been submitted that the appeal is pending before the tribunal and the next date for listing is 4th August. Stop. It is expected that the tribunal shall endeavor to decide the issue of maintainability of the proceeding before the adjudicatory authority, a regulatory authority. I have a regulatory authority, RERA. The tribunal shall also take note of the execution proceeding that has been initiated by the complainant and an order has been passed by the regulatory authority on 16th July 2025 directing the district magistrate to take steps to execute the order within a month from the date of receipt of the certified copy of the order. Very well. Go before the tribunal. Tribunal will take steps.
My lord has been kind enough to state the execution proceeding.
No, I have given you liberty to approach the tribunal with this order. The tribunal will take steps, and 4th is the date.
And the tribunal will decide the point first. They watch.
If you oblige, my lord.
I'm grateful to you.
Only one indulgence. Item number 8, I was led by learned government leader.
Government leader? I do not know.
I have indicated to your lordship.
Only indicated I have heard. Nothing will be reflected in the order sheet.
Indicated to your lordship's officer also.
It will not be reflected. You know this practice of this court. Whoever is present.
He was in another court.
Oh, it cannot be helped. Yes.
My lord, 9 and 10, my lord, both are similar matter. That non-payment.
Matter which appeared that day, your lordship. I have not instance and we have procedure to provide ill affairs, your lordship. I need some time to get back.
Last occasion, this same submission has been advanced. My lord, I have given, my lord.
Wait. The thing is, money has to come.
Yes, kindly
money has to come.
I'm trying to help you out, your lordship.
Yes.
There are a bunch of
Yes, I understand.
The woman ill affairs directly will pay.
Yes.
The matter appeared on Tuesday. We are on Friday. Lordship, the woman ill affairs will pay. Our report will be submitted on next day.
Indrajit Ghosh. Who is this Indrajit Ghosh? Yes, 55,000 bill submitted. Now 55 lakh. 55 lakh. Unpaid is 46 lakh. You give a copy to him also so that he can take instruction.
These all are outstanding dues. Some dues has been paid. I have paid. My lord, file a supplementary affidavit.
Please come. The petitioner alleges part payment of dues. Stuff. A substantial amount of the petitioner's bill remains unpaid. Stop. Learned advocate representing the state respondents shall revert with necessary instruction as to when the payment will be made in favor of the petitioner. When do I keep it?
Lordship, sometime is because this is a combination of 17.
I see this.
17.
Is it my latches?
So I am not fighting here. I am trying to.
Yes.
Lordship kindly keeps it on the 2nd week of August. 18th or 19th, it possible just after the independence.
Second week doesn't come to 18th and 19th.
I should have taken up.
Second week is 8th of August.
Sometime in that week, I hope I will come
8th.
better for
8th. 8, 9 and 10 same order. You are there?
From 1 and 2.
In both the matters? All right.
Well, may I take back this?
Take back. I don't need take back.
9 and 10.
Give a copy to your learned.
Yes, I
friend.
am.
Take instruction.
I am 100.
11.
11 and few matters are there. Your Lordship, if your Lordship recalls, with regard to not election but two other projects, but of PWD. But with regard to the first one, demand has been sent. I have the instruction, demand has been sent, will be disbursed. But with regard to the
1 minute.
With regard to the second one, Prasad Enterprise, Your Lordship, I have a communication of 2018 in July, whereby my learned friend's client was sent an intimation over email. 3 documents are required. I can hand over that email because that email was not replied.
All right, wait. 11, we can pass order. I'll keep it on 8th. Come back with instruction. Has any part payment made?
50%
payment. Same as 9. And 12, the petitioner alleges non-payment of the bills. Stop. Learned advocate for the state respondent submits that certain documents are wanting from the petitioner for which the bills cannot be processed. Stop. Let the details of the documents required to be submitted by the petitioner be made known to the learned advocate so that the documents which are wanting may be handed over to the respondent authorities for processing the bills. Stop. Release the matter on 29th August.
আমি এটা না আপনাকে কিভাবে দেব বলুন প্রিন্ট আউট নিয়ে দেব
12 হয়ে গেছে
হ্যাঁ খুব ভালো হোয়াটসঅ্যাপেই পাঠিয়ে দিন
My lord, I'm appealing for the state respondent, my lord. In this matter, my lord, 40% payment has been made, my lord. We need, my lord, another 8 weeks, my lord. Rest of the payment will be made.
8 weeks? Why?
1 month or 2 months, my lord. At 2 months.
My lord, one more indulgence, my lord. In the PR portion, there is a typographical error. I have prepared a supplementary affidavit, my lord. So that may be kept in the record, my lord.
But when he has filed the writ petition at that point of time, payment was not made. What happened?
No, that was made. Some part.
Subsequently, my lord, some payment has been done. We have already, my lord, issued 7 days back, my lord. Just now I had a talk with Joint Secretary PWD. We had requisition from the Finance Department. Kindly give us some time, my lord. But kindly give a mandatory direction within, my lord. We are praying, my lord, 2 months, my lord. Whatever order your lordship will pass.
What is the typographical error?
My lord, typographical in the prior portion, my lord, kindly come to the prior portion. That amount was written 33 lakhs and odd. It will be 17 lakhs and odd. We have received that amount. There is a typographical error. It will be 17 lakhs.
That's I'm saying, my lord.
That.
1 minute. 3319147 is incorrect.
Incorrect. It will be 1776603. And 4075714. That
put it down in a piece of paper and hand it, and I'll give you leave to correct it.
Yes.
And there is another figure 7,56567. Is that correct?
It is correct. 756,567 correct, but 4075714 that will be 253.
Whatever is the correct figure,
yes,
please put in.
Yes.
There are 3 pending bills, my lord.
Leave granted to the learned advocate on record of the petitioner to rectify the figures in prayer
And as well as
A.
the body.
In the body also, in the prayer and body paragraph.
A body whether he can correct matter subject to lordship.
Prayer he can correct and body he cannot correct.
Number 1
Supplement.
and paragraph 11. Same thing, my lord, same amount.
You put it down in a piece of paper where the correction is to be made.
Supplementary copy কাকে দিই?
তাহলে in paragraph number such and such and prayer. And your submission is when will it be paid, disbursed?
But kindly give us last paying matter 2 months whatever direction lordship will pass.
Acha. Learned advocate for the state respondent submits that part payment has been made and the balance will be released shortly. Stop. 8 weeks time has been sought for. In view of such submission, release the matter on 12th September. Communication made by the Executive Engineer, Nodia Construction Division, PW Directorate, dated 23rd April 2024, be written with the records. Make the correction. Make the correction.
Immediately I will.
Yes. But another thing, my lord, this Executive Engineer Nodia Division is not a required party, my lord. Because this is, my lord, I have received that.
Your instruction is from the Executive Engineer.
My instruction is, my lord, from the
PWD.
In Nodia Construction Division.
Acha.
Both are different. Nodia Construction Division, PWD. And he has made party Executive Engineer, Nodia Division, PWD. Both are different. One
doesn't matter. I'm not deleting anybody, but if the proper authority is there and they are proceeding, then it is all right.
Alright, I'm giving the.
I'm for the state
Item number 14 to 24, my lord. I'm for the petitioner, my lord. These all are analogous matters, my lord, for payment of dues, my lord.
From which department?
My lord. Tender.
Home and Hill Affairs.
My lord, tender was floated, my lord, by the Government of West Bengal, Office of the Block Development Officer, Horirampur, my lord.
BDO. In all matters, BDO.
My lord. Separate tender notice was issued.
Separate tender notices?
For separate work, my lord, during
Yes.
the COVID-19, my lord, after COVID-19, my lord, school repairing of the school.
Whatever.
My lord.
Yes, Mr. Chaturvedi.
Part payment has been made, my lord, out of 1,73,528. 31,235 has been.
My lord, that has been paid, my lord, before filing the writ petition.
What about the balance?
Amount, my lord, paid shortly.
When?
Lord.
Have you taken instruction?
Yes.
Well, does it say that it will be paid?
No. In this instructions, my lord, paid as when fund is made available.
This is the issue. This is what I want to know. Fund will made available, fund will never be made available. So these people have to be taken on terms.
Yes. That is the instruction.
Let me see your instruction.
Yes. Thank you.
The petitioner alleges non-payment of the bills raised. Stop. Learned advocate for the state respondent submits that part payment has been made and the balance will be paid on allotment of fund. Stop. Paragraph.
My lord.
As the
one indulgence, my lord. My lord, kindly record that payment made by the authorities, my lord, before filing of the writ petition.
A part payment was made prior to filing of the writ petition.
My deeply obliged.
As it appears that the petitioner has performed the work in terms of the work order and no dispute has been raised, accordingly the authority would be bound to release payment without any further delay. Stop. Hearing of the writ petition stands adjourned till 12th September 2025. Stop. All payment shall be all payment in terms of the work order shall be released prior to the adjourned date.
Deeply obliged, my lord.
Instruction to be written with the records. Next, who is appearing? 15. Are you there in 15? 15 none appears. Who is appearing?
My lord, 15.
Did you inquire?
Yes, my lord.
Yes.
15, my lord. Rituparna Mitro.
And nobody leading. Nobody leading her.
No, my lord, I have served notice to her, my lord.
Yes. Only
After
one.
mentioning before your lordship, my lord.
You make a phone call and come back after recess.
After recess.
Next one. Mr. Boshumallik, are you not appearing in these set? Payment of dues? BDO tender matters.
These are all different matter.
Yes, different matters. What?
Instruction will have to appear.
No, in none of the matters.
None of maybe Milord, because two, three matters because on the last occasion, Milord.
No, those were the earlier ones. Election matters are different. These are work orders.
These are different matters.
These are work orders.
I have no instruction.
One Rituparna Moitro is here. Make a phone call, come back, I'll pass it over. Next 16.
16, Lordship, I am appearing for.
What is your instruction?
Lordship, part payment was made, Lordship. This is my instruction, Lordship.
Same video?
Same.
The same order will go down. Yes. Record your appearance.
Yes.
Next. 17.
I'm for the statement.
Yes. What is your instruction?
Instruction. No instruction.
Did you seek instruction? You sought instruction from whom? Where is your brief? Open your brief. Who is the respondent? Anybody leading you in the matter?
My senior advocate is sort of not coming.
He has not come to court.
Yes.
Are you there in the panel?
Yes, ma'am.
You are there. Are you engaged in the matter? You didn't take instruction.
No,
Why? Your senior didn't tell you what to do. When did you join the panel? Very new. First matter. I'll make it not today. Come back next Friday with instruction. All right? Call the next one. At order ligin to. Adjourn for the day on the prayer of the learned advocate for the respondent for taking instruction in the matter. Yes, next. 18.
I'm for the same block.
Same block.
Some amount has been released.
Very well. Same order.
My
As in
instruction
14. Instruction written with the records. Yes, next. 19.
19, my lord. Miss Debrina Dashgupta is appearing for the team.
Make a phone call, I can pass it over.
20, I am appearing.
What is your instruction?
The part payment has been made.
Part payment has been made.
They have assured that rest of the thing would be paid
Well,
when the fund is
put your instruction on record, same order as in 14. Yes. 21.
I'm good.
Lordship, 21 for the state lordship.
Same instruction?
Same instruction. Part payment
All
has been
right.
done, lordship.
Instruction written with the records. Give.
21. Right.
Next, 22.
22, my lord, I am appearing for the state, my lord, same instruction.
Same instruction?
Lordship,
Yes.
12th September.
12th of September.
My lord.
Yes. Slipped onion in. Who is there? 23?
Deepankar Ghosh.
25.
Phone. 24?
My lordship, I am appearing.
What is your instruction?
Part payment has been made.
Part payment. And all these payments were made prior to the filing of the writ petition.
In this case, yes, your lordship.
My lord.
All matters. Part payment prior to the filing of the writ
My lord,
petition.
every matter, each and every matter, my lord.
All right. 24. Same order as 14. 25.
My lord, I am appearing for the petition in this matter. My
My lord, I am for the state.
Yes.
My lord, let him.
Let him make
My lord,
submission.
one indulgence, my lord. These three matters will appear at 2 p.m., my lord.
All your other side, in case they are there, it will be taken up at 2. Otherwise, next Friday.
This is my affidavit of service, my lord. My lord, here, my lord, work orders was issued, my lord. by the Pachakot High School, my lord. And your lordship, I have completed the work, my lord. 2 lakhs.
High school.
High school, my lord.
Is the high?
No, my lord. My lord, tender was floated, my lord.
By?
If your lordship kindly comes to the
For renovations of the school building.
By whom?
By the Sarvashik Commission.
By the mission. All right.
Actually, the tender order was floated by the school at the instance of Sarvashik
My
Commission.
lord, 2 lakhs has already been paid, my lord, before filing of the writ petition, my lord. Now, my lord, 3,32,000, my lord. 965 is due and payable, my lord.
Lordship, kindly come to page 23.
Yes.
It is a certificate issued by the field engineer.
Yes. What does it say?
It has said that the amount quoted in the tender and the work done, that is enough. But it is not a completion certificate. And page 35, 36, and 37, school has alleged that entire work of the tender has not been completed.
Why don't you tell these parties that, see, you will not be entitled to the money because you have not performed the work accordingly?
My lord, the work has been completed, my lord. My instruction.
Kindly
Waiting for the DIC, my lord. Number 5, I have made several complaints, my lord, with regard to the work to the, my lord, district education officer and also to the DI, my lord.
All right.
That the work is not complete.
All right.
So that, my lord, I shall bring everything to the timing permission to file.
All right.
Page 35, 36.
Payment is made by the respondent number 3.
My lord.
Payment has to be made by the respondent number 3.
All right. Where is your representation seeking payment?
My lord.
My lord,
The last representation is, my lord, page 38, my lord.
38 is the teacher in charge. Teacher in charge is not making payment. Please come. The petitioner alleges non-payment of the bills.
My lord, kindly come to page 27. There is a representation to the district education officer.
Acha.
My lord, respondent number 3 is the, my lord, sanction.
Stop. Learned advocate representing the state respondents and the teacher in charge of the school submits that the petitioner did not perform work in accordance with the work order issued. Stop. Paragraph. As it appears that the bills of the petitioner are pending consideration, pending payment at the end of the district education officer, and there are allegations that the petitioner did not perform the work in terms of the work order, accordingly, the district education officer, Sarvashikha Mission, Purulia, the respondent number 3 herein, is directed to consider the prayer of the petitioner for releasing payment after giving opportunity of hearing to all the necessary parties, including the teacher in charge of the school. Stop. If it appears that any amount is due and payable to the petitioner, the necessary steps for payment shall be made.
Deeply obliged, my lord.
Writ petition disposed, steps shall be taken within a period of 8 weeks from the date of communication of this order.
Only one thing, subject to the satisfaction that the work has been completed, because I am
obviously this is what has been recorded. I have recorded that.
Giving opportunity of hearing to all the parties.
Yes, next.
Most obliged.
My lord, in this matter, my lord, I am appealing for the petition. This is my affidavit of service, my lord.
Yes.
My lord, here.
Which other side?
My lord, God of dust, my lord.
Nothing doing, not today. It's already time. Next, 27.
My lord, 27, I am appealing for the petitioner, my lord.
Yes.
My lord, here, my lord, the sanctioning authority is the, my lord, BDO, my lord.
What is your instruction?
My lord,
not in instruction.
3,79,655 is due and payable, my lord.
I'll post it next week. Let them consider. Achha, where is the representation? The petitioner alleges non-payment of bills. Stop. The representation seeking payment is pending consideration at the end of the executive officer.
No, my lord. The respondent number 5, my lord. BDO.
The BDO?
BDO, my lord.
Where is your representation before the BDO?
My lord.
Lord,
and the P2, my lord.
What is this, page 23?
Malad 23 is Malad similar similar order has been passed Malad by the coordinate bench Malad that has I have annexed Malad. That in this instance Malad this order was passed Malad. That's why.
Magistrate will consider.
Who will consider?
Respondent number
BDO consider. Sanctioning authority to BDO.
Annex
Right.
2.
Malad, representation has been given to the district magistrate Malad as he will consider Malad, but the sanctioning authority is the Malad BDO Malad.
Why will the DM consider?
Malad, because Malad we have.
Where is your representation to the BDO?
Malad page Malad
21.
21.
No, there is no representation to the
Malad,
BDO.
page 21 to the executive officer Malad.
Yes.
The Bardhaman Panchayat Samiti Malad.
Then
Executive office.
Malad, then respondent number.
respondent number 4 will consider.
4 Malad. Respondent number 4.
Pradeep, respondent number 4. 8 weeks. Pradeep, page 24. There are similar orders. হ্যাঁ এখানে রেসপন্ডেন্ট নাম্বারটা দিয়ে দেবেন, অন্যগুলোতেও এই জিনিসই করে দেবেন। এটা আমি 8 weeks বললাম, not 10। এটা ঠিক আছে? Yes.
But this matter Malad, I am appearing for the petitioner Malad. This is my affidavit for this Malad.
Who is your other side?
Malad, answer.
What does the report say?
Already disbursed now. Executive officer already passed.
Malad, till now we have not received Malad 25,50,890.
What does the instruction say? দেখি চটপট দেখি না।
Here Malad, there is an order of your lordship also which has been passed Malad.
No fund has been received. Is it in this matter?
Dotto construction.
Requisition for fund in the scheme Rajaram Mahato Para. Is there a contempt application pending in this matter?
No Malad.
Then what is this?
Notice already served.
Contempt notice.
Contempt notice was served Malad, but no contempt application is pending Malad.
Is there any order in your favor?
Yes Malad.
Where is it?
Malad, if your lordship kindly comes to.
So you should say all these things.
Malad, P11 Malad. Annex to P11 page. Malad, page 39 Malad.
Yes, Dr. Construction. Yes. There was a direction for consideration of the representation. If any amount is found due and payable, it will be passed. Then what happened?
And nothing happened Malad.
Nothing happened. You file another writ petition.
Malad, because Malad, if your lordship kindly sees Malad, I am relying on a decision Malad. If your lordship kindly comes to.
What? For execution of the order passed?
Malad, no Malad. Page 27 Malad. Malad, there also Malad 2 writ petition was filed Malad. One that was not considered Malad. If your lordship kindly comes to page 27 Malad. After that Malad, same nature of work Malad, same SDO Malad has released the payment Malad. But I have
one after another writ petition will be filed, an order will be filed.
What? That I have told Malad.
What you have told?
Malad, your lordship kindly considers Malad.
In absence of your lordship's order, the executive officer already forwarded to the.
No, only forwarding will not do. Money has to trickle down to the contractor. Under process. আচ্ছা লিখুন তো, learned advocate draws attention of the court to the order passed in favor of the petitioner on 24th April 2024 in WPA 29104 of 2023, wherein direction was passed for consideration of the petitioner's bills, and if any amount was found due and payable, the same to be disbursed in favor of the petitioner. Stop. Payment is yet to be made. Stop. Learned advocate representing the state respondents relies on the communication dated 17th April 2025 by the executive officer of the Bandwan Panchayat Samiti to the district magistrate Purulia seeking for funds. Stop. The fund is yet to be made available. Stop. Hearing of the writ petition is adjourned till 8th August 2025. Stop. An affidavit shall be filed by the district magistrate as to when the payment can be made in favor of the petitioner.
Deeply obliged.
No.
29.
My lord, I am for the petition.
Yes.
What is the Assembly election 2021 matter, my lord?
Assembly election 2021.
My lord, it's a fund.
Oh, you are there for the state. What is your instruction?
I need only 2 weeks time, my lord, because my lord, I have already asked for the instruction, my lord. They said, my lord.
Where is your bills are there?
My bills are in the writ petition, my lord. Kindly see page 31. My lord, before my lord filing the writ petition, they released my lord 1 crore. My lord, now my lord 1 crore 40 lakhs is due. This is the situation, my lord.
Which election? Which election?
Assembly election 21, my lord. The tender notice was floated by the district magistrate.
DM.
For the my lord the.
The petitioner alleges non-payment of the bills. Stop. Learned advocate representing the state respondents is directed to revert with instruction as to when payment can be made in favor of the petitioner. Released on 8th of August.
Get full time. Under the service may be.
Service taken on record. 30.
30, I appear for the petitioner, my lord.
Yes. Who is your other side?
I have served, my lord, but
Do not know. Come back. 31.
same, I am appearing for the petitioner.
This advocate is also not there. 32.
32, I'm for the petitioner.
Yes. Who is your other side?
The other side, my lord, I've served, my lord.
You're nothing doing.
My lord.
33.
I'm for the state.
You're for the state. Now the petitioner is not here. What are you waiting for?
45, my lord, is that EWC certificate.
Oh, EW. Who is your other side?
Yes, Mr.
Boshamulli. Take it, 45.
Today, my lord, I'll say something, my lord. If your lordship can keep this. I'm inviting your lordship to off.
अच्छा ये
Anytime at this point, my lord, I tell you, lordship, my lord, my faculty will be closed, my lord. In spite of lordship's order, they are not allowed in the participation.
Act on the basis. Sorry.
Adjourn motion will be taken up next week. Today it cannot be done. Next week it will be taken up.
Party, the respondent will act on the basis of the server copy. Otherwise, my lord,
All right, server copy.
because why?
By default, it is there in my order, usually.
My lord,
Server
why?
copy. Yes, server copy ta diye deben Pradeep.
No,
No, not fixing. It will be there in the list. Fixing is 2nd August. Is a Saturday.
We have a working day on that day.
Oh,
That is why we are just trying, my lord, our luck, my lord.
No, it can be taken up prior there too also. You never know.
I'll be very candid to your lordship. Kindly does not take me amiss, my lord. Both of us are not there, my lord, till the 31st, my lord. That's a problem, my lord.
Somebody here, you will not be there.
No, I'm till 31st.
Keep somebody there and mention so that it can be posted on the 2nd. In case it is taken up prior to that date.
Definitely. My lord, Mr. Nag will be here, my lord.
In respect of Article 44, there is direction upon us to serve upon the husband. We couldn't locate the husband. Service is not yet completed. Your lordship, can take it up in the next week?
44.
44, This is that matter.
Called up. Then
My lord, may I be permitted to mention, my lord, item number 41 of today's list. There's an interim order that will expire on 30th of this month, my lord. If your lordship kindly takes it up Monday or before that, any other day, my lord, at the top, my lord. 41 of today's list. Adjourn motion.
Adjourn motion. It will be taken up next week.
Because interim order will expire on 30th.
Let it remain where it is. I'll see what is to be done. If it is not taken up prior to the 30th, then mention. And bring your other side also. Yes, call please.
With your ladyship's kindly, may I mention a matter?
Petitioner kothay?
My lord,
Yes.
item number 15, 19 and 23, my lord. I'm for the petition.
Let it remain in the list because I'll take up hearing matters now.
In that case, my lord, kindly all these matters will be come on
Friday.
next Friday.
Next Friday.
Yes. Take instructions in the meantime.
With your ladyship's kindly, may I mention a matter?
So this is not the time to mention. What do you want?
Your ladyship, we were there in item number 7 of today's list. So in that matter, the petitioner submitted that Mr. Jishnu Shah, learned senior counsel, is unwell and he won't be able to appear, and due to that reason they have sought for an accommodation, and the matter has been kept for Monday. However, Mr. Jishnu Shah, we would like to bring to your kind attention that Mr. Jishnu Shah, senior advocate.
Well, I am there. I am there online. I don't know why my learned friends making the submission. I'm running a very high temperature. I've appeared in some matters to seek adjournment virtually. I don't think, my lord, this is called for. I would never, my lord, make such a representation in court after 35 years of practice. I do not know, my lord, why these kind of submissions made.
The only reason why I am mentioning this matter is that I am an officer of, I am for the resolution professional. The only reason why I am mentioning this matter is that I am an officer of the court, and all the expenses which I incur are subject to approval of the COC. The COC members, they approve my expenses, whatever I incurred. I have engaged a senior counsel for this matter, and in the morning it was submitted by the petitioner, the counsel for the petitioner, that Mr. Jishnu Shah, senior advocate, is unwell. However, we have come to know that he was appearing in NCLT. So due to this reason,
I have appeared, my lord, in a matter to seek adjournment virtually. I am, my lord, unwell. My lord, is my learned friend doubting it? After so many years practice, I am, my lord, seeking an adjournment for a day.
Before the honorable bench.
I do not know, my lord, who encourages people to make these submissions after 35 years.
I can never doubt you, sir. Just I am making a submission before the honorable bench that what has been instructed to me.
Listen, this was the instruction. Whatever is there is live streamed and everybody knows what has happened.
Yes, your ladyship.
Now it has been adjourned till Monday.
Yes,
please come on Monday.
Definitely. Grateful, Lord.
I'm grateful, man.
Yes.
My mate, please, Lordship.
Yes.
On the last day, my lord was pleased to, my lord, direct me to start from the very beginning, my lord, the facts of the case, and therefore, my lord, to go into the merits of the case. Because, my lord, there are 4 criminal cases. My lord, one is sexual assault case number 397, one is 314, and one is 340. Now, my lord, we have also made a short notes of argument which was directed by your lordships. Now, my lord, we have submitted on the other day also. No. Now, my lord directed me that we started from the very beginning and we had compiled it in one form, that is scan 4 of 2024. Now, let first to begin with case number 397. Now, all these 3 criminal cases, being sexual assault case number 397, dated 11th of November 2013, sexual assault case number 340, dated 11th of November 2013, and sexual assault case number 314, dated 19th of August 2013, arising out of a property dispute, which is named as 9A Short Street, which is just behind the house of the Commissioner of Police, Calcutta. Now, the entire surroundings are covered by my lord TC footages. Now that whatever happens there, my lord, all would be reflected there. Now all those cases had gone up to Supreme Court. Now my lord, Supreme Court initially quashed all the criminal proceedings, not only these three, along with the other criminal proceedings. Now thereafter, the state of West Bengal moved up to Supreme Court again. And when the Supreme Court was of the view that the three cases would be restored again and to be sent back in original position. Now the case was started again here. But so far 397 is concerned. My lord, it was started on 11th of November 2013. And before that, the petitioner, my lord, apprehended that the state, that means, my lord, the Calcutta police, is hatching up a criminal conspiracy. And my lord, we had come to know it from the mediation center at the very Supreme Court itself. Now, my lord, if your losses, my lord, kindly turn to page 49 to 57 of Can 4 of 2024, of Can 4 of 2024, page 49 to 57, your losses will get the Supreme Court orders.
Yes.
We have page 49 to 57. There are two cases. Can put the bar for? Put the bar for. And page 49 to 57.
(49 to 56). Yes.
9 to 57.
57. Yes.
The paragraph 10 at page 51. The appeal is accordingly disposed of. Though the learned mediator, Mrs. Bharuna Bhandari, insisted that she does not require any honorarium, that's all, all this there. Now, can you come to page 53? When the Honor Supreme Court sent it back again.
The appeal is disposed of. The declaration is granted. We direct the parties to abide by the terms and conditions of the deed of settlement. That means some settlement was entered into. Page 51. All right.
There was initially there was a civil dispute. Now that when the opposite parties found, particularly the Calcutta police found that this man is escaping or he cannot be tangled with. Now that they started a new theory of implicating me one after in another cases.
All right.
And therefore we have chronologically taken up the cases which is 397, 340 and 340. Today, we shall dispose of all these three cases, or I shall summarize all these three cases. All right. Now, thereafter, kindly come to the next page, page 53. And that was at the instance of State of West Bengal through Calcutta police. Therefore, the following cases appearing in paragraph 4 of the judgment dated 17th of July 2018 are deleted. Shakespeare's one in PSK number 314, Shakespeare's one PSK number 340, and case number 397. Consequently, all the above three cases are directed to be proceeded with in accordance with law, since they are not otherwise settled. The orders passed by the trial court discharging the accused in the above three cases will stand recalled. The cases will proceed from the stage they are pending with the trial court at a relevant time. The trial court is directed to summon forthwith those who have been discharged and proceed with the matter in accordance with law.
Tell me one thing, the cases which stood settled,
Yes.
page 51, were there more cases apart from these three?
Various cases.
Oh, various cases.
Various cases, my lord.
Few have been settled and these three have been directed to be taken out for hearing afresh.
Yes, particularly by the Calcutta Police ASA.
Yes.
Detained Deputy Commissioner of Police.
All right.
Bojna Shah, I'm sorry, Bojna Shah. Now, my lord, kindly come to, when we came to know about the mediation center, kindly come to one of two letters dated page 58 and 60, page 58 of can 4 of page 58. Our apprehension, my apprehension, law-abiding citizen, each of the complaint is that one Rotanlal Mahata, Mamata Agarwal, Darkina Sen have been cheating people, showing property 9A Short Street, Calcutta. We have managed to prove their crime, as can be seen from the following document, or such as the documents. Even kind of look at paragraph 3. Order of well-respected Honorable Justice Sanjeev Banerjee in Civil Suit number 41 of 2011, imposing penalty on Rotanlal Nahata, the opposite party who are shouting here, for filing the petition and also collusion or rumission, Raki Sen, Darik Sen, Mamata Agarwal, that my learned friend was being a voluminous document of Mamata Agarwal. He is representing Mamata Agarwal. And who is the lady responsible for murdering 2 persons, and against whom 2 murder cases are pending.
All right.
Anyway, number then 50, then 60. And I come to page 60. Another letter dated 18th of September 2013. Enclosed my letter dated 22nd of August 2013 is extraordinary. Next paragraph. I have come across newspaper reports on Monday of some vandalism at Montessori School at Short Street, and I once again fear that these people have done this mischief to once again lodge false complaint and frame me trying to take advantage of vandalism at Christchurch School, Dum. But as I was busy preparing for Vishwakarma Puja, my factory at Barakpur, my letter is delayed by 2 days. I request you to go through all details of this dishonest person, and you will come to know what must have transferred. Now, it starts with the case of first case 397, page 11 of Can.
Page
11.
11 of Can.
Of Can 4.
Yes.
Just look at me, I'm very short. That after a lapse of more than 2 months from the date of his above-mentioned letters, page 11, Roman 3. That after a lapse of more than 2 months from the date of his above-mentioned letters of apprehension, unfortunately on 13th of November 2013, the petitioner was arrested in connection with Shakespeare's case number 397. This is the first case. Dated November 11, 2013 under section 120B, 143, 149, Code 58, Code 59 of the Indian Penal Code. Next is the FIR, I'm reading it. So the incident took place on 11th of November 2013 at about 4:40 AM, IPC Tower Code. And the complaint was lodged by Shofiq Ahmad, alias Papu. And he could name of 11 persons, but did not name the present petitioner Parag Mujumdar. What is the gist of the FIR? I have quoted from the FIR itself. It has been alleged in the FIR that few days prior to the incident, the complainant received phone calls that they were going to be attacked and evicted from the property. On November 11, 2023, when the complainant and others were sleeping at 4:40 AM, they heard hue and cries and woke up from their sleep. The complainant came out and saw 10-12 persons, including few ladies, had gathered at the compound armed with sticks and iron rods. In the meantime, one promoter came to the spot and then himself, along with the complainant, took sticks and chased the persons who had gathered in the compound. Since the miscreants were not leaving the property, the complainant and promoter brought out a licensed gun of Rakhundra Nehta and chased the miscreants. And thereafter, the miscreants took shelter inside a wooden house and subsequently they fled away. But then, one file, the charge sheet was submitted under section 458 and 459 of the Indian Penal Code against the petitioner. Now, I shall show to your Lordship what is the ingredients of section 458 and 459 IPC. But this was based only on the statement of Mr. Sofiq Ahmed, none else. And there is no material to connect me with the alleged offense. And fortunately, my lord, by affidavit দেখো আগে affidavit বার করো 397 affidavit বার করো But this is a copy of the charge sheet.
Is it not annexed? Is it not annexed?
But I have missed it. This is my fault. This is not my, not all learned. So this is my fault. I have missed it. This is the original, my lord. I have brought it, but this is huge, voluminous.
All right.
Charge sheet 397 charge sheet copy টা দিলাম
Yes.
Now let's try to come to next 6. That one of the accused, namely Noor Ali, paid for all the relevant papers and documents under section 207 of the Code of Criminal Procedure, including the camera footage so fixed and lying in the place of occurrence. Moreover, the police in page number 116A of the charge sheet stated that inverted comma. During investigation, alamas including the footage of CCTV cameras were seized from the PO and witnesses were examined. Services of photographs and plan makers of video had taken that the said CCTV footage was seized in connection with section K2 of 398-13. But unfortunately, 14 years have gone by in the meantime. There is no CC footage of number 1.
There is?
No CC footage, which we have wanted.
All right.
That from the CC footage, it will be clear that whether Paragwinder was there or not.
The CCTV were seized.
We have seized, but they are not producing in court.
They are not producing?
No. We have annexed all the other seats here.
All right. You all prayed for.
The child just said, let it be kept in the record.
Did you all pray for?
Everything with an application. Even that person had made an application to the lordship.
Yes.
Addition of party. That addition of party has been allowed by your lordship.
Yes.
But till today, 14 years have gone by. The CC footage is missing.
Missing?
They are not producing as yet.
Does it appear from the charge sheet that these CCTV footages were seized?
Yes, page 16A of the charge sheet.
Yes.
Page 16A of the charge sheet, page 13. 16A, can I have a look at page 16A?
Yes, 16A.
The last but one paragraph. Subsequently, under order, control further in the case has been taken up by the
homicide squad.
Alamas, including footage of CCTV cameras seized. They have admitted it.
Yes, from the place and witnesses examined. Services of photographers and plan makers were taken. Was seized in connection with 398.
They are not producing the footage of camera number 1 still today, 14 years have gone by. We have made the application.
How many cameras were there?
There are 4 cameras.
4 cameras. You want?
Camera number 1, which is the main camera, which will show the entire 9 short state that is not being produced by them.
All right.
And we have made the application, we have annexed here with can 4. There is order sheet of the learned treasurer. Let it be kept in the record till today. Well, there are 77 charge sheet witnesses. 14 years have gone by. What will happen? And if so, my lord, have a look at, my lord, the ingredients of section 458 and 459. And look at section 458. It is
Which provision?
450, section 458 of 450 and 459.
Acha.
Upon which the charges has been submitted.
458. Lurking house trespass.
Yes.
ভাই কি তারা শিক্ষা কোথায় যেটা যেটা দিয়ে বলছে অনলি কনস্পিরেটর
আমার বিপরীতে তো আছে তো আমার বিপরীতে তো আছে না না অনলি কনস্পিরেটর বার করে দিলাম 4টে
What are you searching?
No, no, my lord, what the state has said. My lord, they are clearly stated in the affidavit. And I'm reading it. This is
Which affidavit?
your affidavit, 397.
I have submitted 4 affidavits.
397, case number 397. My lord, they are submitted. My lord, this is, my lord, they are affidavit in operation in case number 397. Roman 19, page 12. Roman 19, page 12. Point number E. He was not present at the time of incident.
He was not present.
Yes.
They have mentioned.
Just.
No, it's all right. You say, I take it. Not present.
Yes.
Petitioner not present.
The whole operation was orchestrated and done under his direction.
All right.
He is a principal conspirator.
So he is a conspirator.
But after long days, after 14 years, they are saying that I am the conspirator. And there are 77 charge sheets. How does witnesses? How does conspiracy comes into play? It comes into play when 2 persons or more than 2 persons conspire together, sit together, and make one conspiracy. Well, suppose, my lord, can you excuse me? My lord, there is Calcutta University, there is College Square, and there is Puntiram. But I am myself, I love my friends, is gossiping at College Square. Something happens within the university campus or beside Puntiram. Can it be said that I am one of the conspirators?
All right.
There must be an agreement between the 2 persons, and there must be a material connecting me with the alleged offense. Then how do they connect me with the alleged offense of section 458 and 459?
But will that not be subject matter of trial?
How it can be then, my lord, that's what I want to serve two judges initially. Better dog. একটা কপি যশোর হিসাবে তো can you have a look at paragraph 5? এটাই তো আমার কপি শুধু কপিটা দে না
Certain judgments were handed over earlier. Is this one of them?
Is this one of them? I'm just
Give the name.
Ashok Chaturvedi and others.
Bhajanlal was handed over.
No. Ashok Chaturvedi and others.
Ashok Chaturvedi. Ashok Chaturvedi is here.
Yes. Can you have a look at paragraph 5?
5.
Yes. একটা বার্কার সহ চট্টরাজ দিয়ে দেবো ভাই তোমাকে দিয়ে দেবো সব দিয়ে দেবো 1998 7 Supreme Court cases 698 Supreme Court cases 698 আমার compilation of arguments সব দিয়ে দেবো ভাই তোমাকে
Yes.
Paragraph 5. But this is a case of quashing under section 482 and so far the penal code are concerned 420 467 468 and 120b. What paragraph 5 says? But the question that here remains for consideration is whether the allegations made in the complaint together with statements made by the complainant and the witnesses before the magistrate taken on their face value do make the offence for which the magistrate has taken cognizance of. The learned counsel for the respondent in this connection has asked that the accused had a right to put this argument. The time of framing up charge, what my lord was pointing out to me. And therefore, this court should not interfere with the order of magistrate taking cognizance at this stage. The argument, however, does not appeal to us in as much as merely because an accused has a right to plead at the time of framing up charges, as provided in section 245 of the Code of Criminal Procedure. He debarred from approaching the court even at an earliest point of time when the magistrate takes cognizance of the offence and the summons the accused to appear to contend that the very offence of the order of taking cognizance is invalid on the ground that no offence can be said to have been made out on the allegations made in the complaint petition. It has been held in a number of cases that the power under section 482 has to be exercised sparingly and the interest of justice. But allowing the criminal proceeding to continue even where the allegations in the complaint petition do not make out any offence would be tantamount to an abuse of the process of the court. And therefore, there cannot be any dispute that in such case power under section 482 of the court can be exercised, bearing in mind the parameters laid down by this court in several decisions for exercise of power under section 482. We have examined the allegations made in the complaint petition and the statement of the complainant and the two other witnesses made on oath before the magistrate. We are clearly of the opinion that the necessary ingredients of any offence have not been made out. So far as the appellants are concerned, necessary ingredients have not been made out. I'm speaking of 458 and 459. The petition of complaint is a vague one, excepting the bold allegations that the shares of the complainant have been transferred and on court signatures. Nothing further has been stated, and there is not an iota of material to indicate how or any of these appellants are involved in the so-called allegations of forgery. No, I'm not reading. Therefore, my lord, if the allegation in the FIR, if the coupled with the allegation in the charge sheet, allowing the statements made by the witnesses, do not make out any case. Is it necessary to face the trial? Supreme Court says no. This point, my lord, was raised with Honorable Supreme Court. Supreme Court said no, it did not. The same point of law I am involving here, and I beseech your lordships, there is no material to connect me with the offence. remotest even under section 120. And after 14 years, charge has not been framed. Then, my lord, your lordship knows it very well. It's deprived me by way of Article 20 of the Constitution. I'm mentally agonized. I'm mentally demoralized. My business has been paralyzed.
Please, sir.
My lord, there is another judgment of 1991 Supreme Court, page 574. It is not in lawsuits. Sharply, within two Supreme Court cases, 574. And this is very short judgment. Paragraph 3. 3. The prosecution is instituted by a complaint given by one Indian Narayan, director of Sangeeta Estate Private Limited. In continuation of earlier complaint, it is Shasan charge, followed by a further report, it is Shasan charge, in which the vague allegation is leveled against the appellant. Reading, we suspect that our Darwan has been moved away by Mr. Shasan Sar and Sri Chattaraj with the assistance of his help support of Sri Suniti Chattaraj. We carefully and meticulously went through the entire report as well as the statements of witnesses recorded on 161 of the Criminal Procedural Code during the course of investigation. And on Procedural record, we are satisfied that there is no material connecting the appellant with the alleged offense of criminal trespass. The learned counsel appearing under the respondent is not able to satisfy us, showing any material that will justify the implication of the appellant with the offense for which he now stands charged. And therefore, my lord, I respectfully submit your lordship. The allegations made by Sufi Committee in the FIR are vague. I am not named in the FIR. I am not named in the FIR. The charge sheet do not make out any case or any statement do not implicate me anywhere. And the CC footage camera number 1 still today has not been produced before the court after 14 years. 77 charge sheet witnesses, charge has not yet been framed. And moreover, madam, there are other points which I have chronologically evented here.
Yes.
And therefore, madam, there is no use of
Proceeding.
in this case.
All right.
After 14.
All right.
But I have given madam, a graphic picture madam, in my application in Can 4 of 2020. Now, madam, can you come to the next case? Case number 340. Kindly come to page 17, para 15. Can 4, para 15. But this is more interesting than the other. That we appreciate Shakespeare story page 340 dated 16th of September 2013. Page 17, paragraph 15.
Yes. Yes.
That we appreciate Shakespeare story page number 340 dated September 6, 2013. Which was initially initiated under section 147, 148, 149, 427, 379, 458, 506, 120B of the Indian Penal Code. And later on amended as section 120B, 148, 149, 395, 399 of the Indian Penal Code. Thereby 25, 29 of the Armed Act. Their petitioner begged to state as follows. That while he was in custody in Shakespeare story case number 397 dated November 2013 under section 458 and 459, he came to know that he has been tagged in two other criminal cases, being Shakespeare story case number 314 dated August 19, 2013 under section 341, 324, 506, 427, 350, 140 of the Indian Penal Code, and Shakespeare story case number 340 dated 16th of September 2013. Now, that it is very strange that the petitioner was found arrested on 26th of November 2013 in Shakespeare story case number 314 dated September 16, 2013, while he was in custody, already in custody in Shakespeare story case number 397 dated November 11, 2013. He was found arrested in connection with this case. But next is very strange.
Is it done if somebody is in custody? Can you show him to be arrested on a particular day when the person is in custody in respect of another case? Is it done?
Well, if it is very soon, it can be done.
All right.
If it is very soon, it can be done. But my lord, whenever the man is languishing in custody, and thereafter you are showing him to be shown arrest in connection with another case, but this is a very fishy case. This is very fishy.
All right. What are the dates? Because he was in custody from when?
Paragraph number 4. I'm giving the dates.
11th November 2013. He was in
earlier page.
11th November 2013.
Paragraph 11. Have a look at paragraph 11. Page 10. Page 10, paragraph 11.
Yes. Yes.
397. Date of marriage November 13, 2013.
Right.
Then 340. This is also by Sophie Ahmed. Date of initiation 16th of September 2013. Before initiation of 397. Before 397. But he's shown arrested on November 27. Why? Why? My question is why? This is Calcutta police. This is Lal Bazar. One building to another building. One room to another room. Why so long?
And when he was already in custody.
But that is the crux of the case. Now, one kindly come to the FIR of this case. Page 72 of Can 4. Page 74.
Yes.
The instant case was registered on the basis of letter of complaint filed by Sophie Ahmed. In 397 also, Sophie is the complainant. Here is also Sophie is the complainant. The caretaker of the premises number 9 is Short Street, Calcutta, South, if I alleges that the accused Parag Mohundar and Kaushik Sen entered into criminal conspiracy and sent 50-60 unknown persons on 15/9/2013 around 16:30 hours, who formed unlawful assembly, informed the above premises and committed rioting with deadly weapons, wrought disorder and made trespass into the premises 9A Short Street, which was under the control of Shimamoto Agarwal at that time of she was away, and assaulted inmates of the premises by means of each lapsed iron rod, causing physical injuries on their persons. While Sri Ratanlal Nahata, one of the occupants, came to rescue his men, he was also assaulted by the miscreants, and subsequently they took away his license revolver having particular number such and such, along with rounds of ammunition. The miscreants also ransacked the premises of station Chinahata and inmates of the premises with that consequences. That's all. And there is no material to connect him with the alleged offense in 161 statement. There are so many statements, more than 50 statements they have taken out. I have summarized all the statements here in Can 4. Not a single statement, my lord, have implicated my lord Parag Majumdar. What?
No, here the FIR, he is named.
He is named. Then, my lord, what is the opposition? The opposition is conspiracy.
Yes, here also it says conspiracy.
Conspiracy. There is conspiracy. Then how you can connect him with the alleged conspiracy? There must be a meeting of mind between the two persons or several persons. What is the element of the conspiracy? Well, I have already told you a lot. Suppose I am gossiping, my lord, near Rajbhavan. Some incidents have happened near my lord Bidhan Sabha. My lord, can it be taken into consideration that I was one of the conspirators? Because I am the main man, and therefore you are the conspirator. It can't be. There will be a direct or indirect evidence. But conspiracy never comes through direct evidence. It is always an indirect evidence. Why is that indirect evidence? And what is the affidavit? They could never connect me with this offense.
But the evidence is going on. Evidence is going on.
Nothing. Only out of two witnesses have been examined.
Only one witness has been completed.
Only one witness has been completed out of
44.
44 witnesses. Then another 14 years will go by.
From 2017, sir. From 2017.
No. It started in 2007. Then another 14 years will go on. And my lord, sitting here would allow them to continue with the alleged offense. There are a series of points I have edited here from paragraph 15. I am not, my lord, wasting my lord's time. I am just giving you, lordship, the short notes of this. Now let's come the last case. And what they have done, my lord? There are 50-60 persons. What, my lord, Subhigam has said. They have only given 7 names. Why? Even in some cases, further names even have not been given.
7 names have been given where?
In the charge sheet.
All right.
Where the names of the present petitioner transfers in the charge sheet. I've told you. But I have gone through 161 statements one by one, along with my learned juniors. We could not find any touch of Parag Majumdar. Only, and we have been confirmed. When the State of West Bengal was pleased to give us the affidavit in opposition, showing us that he was one of the conspirators. They were telling there are 161 statements and others. It is true there is 161 statements, some 161 statements, but they do not touch Parag Majumdar. And Marat, in one day, it was started on 16th of November. On that day, file goes here, the London magistrate, without going to the case diary, tax Marat once tax 395. I said, show it from can 4 of 2008. কেন কথা বলছিস I said, show to your lordship. Oh, তোর বাইরে যে করবো না যেখানে look at page 83. Look at page 83. Page, it comes from page 81. 81 to 83. Does your last week get page 81?
Yes.
But this is a prayer. Hence it is prayed with your last paragraph.
Yes, yes.
That sections of law 120B, 148, 149, 395, 397, 25, 1B, 27 arms act may kindly be added. Instead, under section 147, 148, 149, 427, 379, 448, 506. Now, kindly come to the next page. This is of 16th of November. And now, come to primary, page 83.
Yes.
Look at the handwriting. First handwriting, adding section, then allowed. It is whose handwriting, madam? It is whose handwriting? It is Pescar's or anybody else?
The prayer of the IO is allowed.
Allowed. It is whose handwriting? Madam, my learned juniors have taken enough pains to collect all these paper, certificate copies from the Bankshal court. Thanks to my learned friends. And thanks to my clients also.
But then whoever has written it, it is signed by the Chief Metropolitan Magistrate.
Would your losses kindly allow it? I don't like to say anything more, my lord, because that will do harm to anybody else. I don't like.
No, we have to take it that it is the judge's order and not the Peshkar and whoever.
Anyway, but
it is the judge's order.
But take an exception to this.
CD was not available that day.
And then, on the very day, without application of mind, have a look at the last paragraph. Let it be kept in the record. In the following report, I have prayer for permission of interrogation accused Paragmundar, who is in PC, such and such, as the accused is wanted in connection with if complexity arises. The prayer of the IO is allowed. And the case jury was not there. Without going to the case jury, he is allowing it. Because from 379 to Dakati. But this is alarming. And citizens, we are in a democratic country. Our liberty is at stake. But I could very well appreciate when I was a postgraduate student. And at that time, you can remember, Mr. Devi Rai, I was the head of Lal Bazar. And that was a Naxalite period. During the period 1970-74. And my lord, this man was shown to be arrested. This is number one. And next, my lord, But kindly come to page 18, Roman 3.
Yes.
But this is very strange. Page 18, bhai. Roman 3. Can 4.
Yes.
That it is curious to note that after initiation of the proceeding on 16/9/2013, there is no order sheet till 15th of November 2013. And the first order sheet starts from 16th of November 2013. But where goes the order sheet? You have started the case against him, and there is no order sheet. But I can be absconding, or I can be shown arrested in, or I am tagged in another case. But there must be an order sheet. Suppose, my lord, today I am not inclined to, my lord, make out any argument before lordship. Then either your lordship will say the matter is adjourned, or list it up next week. There must be an order sheet. But what is this order sheet? But this goes to the root of the case. But I have annexed it. I have annexed the entire order sheet here. Page 83 is starting point. Page 83 is the starting point of Can 4. Please change the word for it. Look at my lord. First order sheet starts with 16th of November 2013. This case was started on 16th of September 2013. But this is very strange, my lord. Well, moreover, my lord, I have jotted down all the points in Can 4. I'm not taking away my lord's time. Now, my lord, let us take up page number 347. Page number 340. Yeah. Now, the last case of sexual assault is 340 at page 23. But para 21. But I should be very candidly honest with you. If your lordship goes to the FIR of this case, honestly speaking, my lord, I am in a somewhat back foot. This might against me, this might go against in favor of them. But the peculiarity is this. Have a look at it. But the interesting point here is that this is a case which was first started in August 19, 2013, before initiation of any other two cases. What they are doing so long? From August, he was taken into custody. While he was in custody, he was arrested in January 6, 2014. paragraph 3, page 24, lot number 3. It is most strange that Shakespeare shown in Peace Case number 314 was started on 19th of August 2013, but he was produced in court on 6th of January 2014. But too long he is in custody. From the very inception, he is in custody. Then, my lord, why, my lord, such a gap? Who will explain this gap? That he was, the case was started in August 19, August 13, August 19, and he was arrested after a lapse of 4 months. Already he was in custody in 2 cases. He was never bailed out. He was bailed out after 9 months. Why the police had suppressed so long? This case, was it a false case? And therefore they did not take care of taking him in custody? Or the police had thought of it, that this was simply a case under section 323 or 325, to put him in grave charges so that they are waiting to put him in a serious offense. What is the motive behind it? I shall explain on the other day. Today is 3:20. I shall explain on that. I'm somewhat tired. Which one? Page. I have a look at page 123 for a moment. Yes. I'll look at page 123. Just reading. Of Canfor. I'm thankful to my landed brother and sister also.
Yes.
Look at it, my lord. Most actually beg to submit, Your Honor, that the brief facts of the case is that on 19th of August 2013 at around 11:40 hours, the FIM, the accused persons and others being aided and abetted to each other wrongfully restrained the complainant and assaulted her with iron rod at her right leg while she was protesting against breaking of name plate leg, which fixed outside the wall of the said premises and fixing another nameplate at that place. And the accused person also outraged the modesty of the complainant by way of touching her body and threatened her with consequences. Investigation into the case is in progress. The instant case has been endorsed in the name of undersigned after the previous SI Noor Ali has been transferred. During investigation of the case, interrogated the noted accused persons, Parag Mujumdar, such and such, with prior permission of learned CGM Alipur. During interrogation of the above accused person, it could be learned that he has been involved in the instant case. The above accused person is being produced before Your Honor court from the Presidency Correctional Home on the strength of production warrant issued by Your Honor's court in the instant case. Why? Why production warrant? After 4 months, my lord, he sought to be arrested by production warrant. The marginally noted accused person has complicity in instant case. The marginally noted accused is needed to be in police custody for apprehension of other cases and if in view of displayed, Your Honor, that such and such may kindly be remanded to police custody. Then, my lord, the case was started on 19th of August. Production warrant dated 6th of January 2014 after 14 months, after 4 months. Why? Now, my lord, kindly come to page 125 for a moment. What is the obligation of London magistrate? I've gone to the complicity complaint of this case as well as I do not find anything in the of the case that would justify the pair for PC, considering the allegations of touching the body of the accused, which does not itself is disclosed intentional knowledge to outrage the modesty of the woman, pair for bail is allowed. If what has been added, other matches is otherwise. I shall conclude it next week, along with the another case, Anandapur peace case. Therefore, I can conclude it by next week, and I shall show the relevant judgments which we are relying upon.
Learned senior counsel representing the petitioner commences arguments, but does not conclude the same. Stop list for fun. 1st August. Next Friday.
Next Friday, the remaining is position.
Yes, yes.
What is it?
Your Lordship, one more thing I just want to indicate. The with the permission of the senior Lordship, my lord, they have give the added parties. They have presented us with the written notes, but they have not filed any opposition. So so it is implied
You
that
have
they
filed
have.
opposition, isn't it?
It is implied. It is implied that they have waived their
They
right.
have not served us the plan for till date.
But mine is writ
No.
petition, right?
And 4 has not been served upon us.
But you have also not filed any objection to the writ petition.
The writ also, you didn't file any opposition.
Your Lordship.
Received.
But they have.
Only one writ has been received by me. That is the second one.
No.
The first one has not been served upon.
There is only one writ petition.
There are 2 writs, Your Lordship.
There are 2 writs.
All right, wow, 2 writs.
Yes.
10830.
Yes.
We are in
5368.
5368 right now.
Yes.
Did you file any
No, Your Lordship.
opposition?
We have filed 2 grants just to add to the parties. We have not.
They are all on record.
Yeah, they are all on record.
Yes.
But the opposition has not been filed because one writ application, the first one, has not been served upon us. Second one. I'll tell you.
If second one has not been served, why will you not file opposition in the first one?
No, the first one has not been. Second one has been served.
But he has no locus standi here. How he has got the locus?
We decided later on.
Yes, because his application has not been allowed.
Yes, sir.
It is pending.
Yes.
This is the reason no opposition can come from him till he is
Your
formally
Lordship,
added.
I think in the last order he's added.
Added?
He has been added as a party. And
Has
that's
he
why
been
he
added?
Yes, yes.
All right, let me see. If you have been added, then you can always file your opposition. It's up to you whether you'll file or not.
They have.
Your Lordship, because my learned senior was pressing his argument, so I didn't thought good to disturb him. So we have not been served the copy of the application, first application, Your Lordship.
What about the writ petition?
We'll file it, Lordship, after my learned senior come.
After he concludes his argument and the judgment is delivered, you'll have enough time for filing the opposition. All right.
I'll file it.
It is up to you.
Let them serve us a copy, Your Lordship.
Your Lordship,
Which copy?
it has been already served.
I'll come back on this. No. The second has been served upon us. The first has not been served upon us, Your Lordship.
With Lordship's permission, may I leave the court, my lord?
Yes, you can leave. Please check. There are so many orders. I'm not going through it separately. Check the order sheets. The matter is there. It is for you whether to file, whether you have got the locus standi to file or all. I do not know. I am to see all the papers to decide. You check up. If you have been added, you can always file if you choose to. And if you choose to file it after delivery of the judgment, you are free to do so.
My lord, may I also take this opportunity to, if I'm be allowed to file my written notes?
Written notes after I hear you. Otherwise, I cannot keep things in my mind. It will become complicated. জানা বাবু এই দুটোকে স্টেপল Please enter your appearance. (106) is the petitioner there? Yes.
This is an assigned matter, my lord. You lordship will kindly recall, my lord. This is a case where the distributorship application of the petitioner was cancelled by the authorities, citing reason that this particular petitioner is a company and company is not entitled to make an application for distributorship. And my lord, a similar writ petition has already been disposed of by your lordship's court, my lord, wherein it has been held the particular condition which based on which this application was rejected has been held to be ultra vires. Now, my lord, I'll be candid with your lordship. Against that order, my lord, an appeal has been preferred against by the state, but there is no order of stay.
There was undertaking by them.
Not to proceed for contempt application.
Not to proceed with the
Contempt application. But so far the judge.
Stay was granted, but there was rejection for
whatever, maybe, my lord, that if your lordship chooses to take up this matter in between, my lord,
Why, if the issue is pending, why to take up the matter?
my lord, that is why I mentioned with your lordship, my lord.
But then why was it mentioned by your counsel for hearing if the issue is pending?
Earlier, one application, similar issue, my lord, they preferred. And in the similar application, this appeal, the question of appeal pending, that has not been mentioned. That's why the earlier single bench passed this order.
No. My lord, may I make it? My lord, the writ petition based on which, my lord, we make these submissions, my lord, appeal has been preferred against that order. But subsequently, identical issue has already been disposed of by a coordinate bench. But in that judgment, my lord, the question of appeal was not mentioned.
Why? Why was it not mentioned?
That was not within the knowledge, my lord. Subsequently, state preferred and recalling application citing that.
They are the petitioner.
My lord, state filed an recalling application citing that appeal is pending. My lord, the learned coordinate bench has been pleased to, my lord, clarify, my lord, since there is no order of stay and, my lord, it has not been set aside, it is binding.
Representing the petitioners submits upon instruction that the issue involved in the instant writ petition is pending consideration before the Honorable Division Bench. Next, where is the undertaking, Degi? The order passed by the Honorable Division Bench on 7th September 2022 in Mat 1146 of 2022 with IA Can 1 of 22 with IA Can 2 of 22, State of West Bengal and others versus Messrs. Kultoli Food Marketing Private Limited and another. The order dated such and such, title has been placed before this court. It appears therefrom that the learned senior counsel representing the petitioner has submitted before the Honorable Division Bench that the petitioners will not proceed with the contempt application till the next date of hearing. The appeal is yet to be heard and disposed of. Paragraph. As the issue is pending consideration before the Honorable Division Bench, accordingly, let the writ petition be delisted for the time being. Liberty to mention the matter after the appeal is disposed of by the Honorable Division Bench.
My lord, you will appreciate that there is no stay in that appeal. And this appeal is lying pending for 3 years. And I am suffering for 3 years.
I can understand, but then,
my lord,
you cannot proceed with this contempt matter because of the pendency of the appeal.
That I have given an undertaking.
Undertaking is there. And if the issue is pending and if you are suffering, why don't you get it heard?
But if your lordship was hearing matters,
at least division bench has some time. The writ courts are
at least in complete.
So you,
but my lord, your lordship will appreciate that until there is a stay, and even if there is a stay, writ court can hear and dispose of the matter, my lord.
It can, but then again there will be conflicting decisions. You never know. You never know.
Well,
This will give rise to complexities and the other writ petitions and other matters.
A similar matter has been disposed of by Justice Samanto.
No, but then an order of recalling.
No, recalling has been dismissed. Recalling has been.
This appeal has not been mentioned.
This appeal has not been mentioned. It is better you get it done from the division bench. Come here, the court will pass order.
That will never. I will have to make. I am suffering for 3 years. Again, I will have to make. You will also kindly fix a date. By that time, let them get it listed and heard.
I have given a date immediately upon disposal of the appeal. You come, I'll hear it. No issues.
My lord, in that, neither that will be heard and that you will.
You can get, if the petitioner, the appellant is not willing, you can get it dismissed for default also. That can also be done.
My lord, whenever I shall go for appearing, mentioning what your lordship knows, what I will have to face. Are you appellant? No. Is there any stay order? No. Then why you are mentioning? Your lordship knows.
I
am not supposed. Your lordship had the experience that
you are suffering. Then what can be done?
Lordship, kindly fix a date. Within that time, if they do not come with any decision, then your lordship will hear it.
Are you the appellant? You are not the appellant, but the state is the appellant. You can take steps.
Samrashan is here, my lord.
Whoever is there, it is a state's appeal.
I will communicate them to pursue the matter so that the appeal may be disposed of.
Kindly give 1 month date, 1 month time to them. Or 2 months, whatever your lordship.
I will convey and communicate the.
It is made clear that in the event no order is placed before, no order of stay is stay or disposal of the appeal is placed before this court by September 19, 2025, the matter will be listed for hearing immediately after the reopening of the court after the ensuing puja vacation. So you still have 2 months time. In case you can get it done within this time, it is all right. Otherwise, then after the pujas, it has to go.
I am not in the appeal. I communicate the
state is the appellant. You are representing the state. Please communicate. Otherwise, see,
definitely,
this is
the appeal cannot be pending.
Obviously.
Deeply obliged.
My learned friend is right also.
Isn't it? It's come back from the division bench.
Yes.
Who is your other side?
Mr. Dhiraj Trivedi. I have informed him already.
Let's see if next day it can be taken up. But the hearing matters are there only on Fridays.
My lord, other than 1st July, my lord, 1st August, my lord, it can be fixed on 8th August, my lord, instead of 1st.
Friday.
I cannot say. Take your turn, because the other matter is continuing. The matter, the first hearing matter, right? If it continues, then I do not know what's going to happen. But then if it collapses, then your matter will be the next matter, because this is going out.
Grateful, my lord.